For delivery of orders, item 1.
We'll have to pass orders. I could only pass in one. The others are pending. We'll pass orders. You'll have it either next week or the week thereafter. I mean, I'll fix a date and accordingly I'll give it up. Item number 5 to me.
Item number 5.
I'll go online. I said, orders. We have passed the order. We have directed the register, academic register, in terms of the directions of the Executive Research Council and the Executive Council to proceed to hold a viva for and give an opportunity to the petitioner to defend her thesis. And we have not gone into any other aspects. We have whatever disputes are there, we have said let it be there as it is. But we have followed the directions or the decision of the Executive Council, and we have asked them to complete it within a period of 3 months. Only you got to submit a certified copy along with the forwarding before the response number 4.
Yes, sir.
You will have it by tomorrow. It will be uploaded today or tomorrow.
Yes, sir. DP of measurement.
You will dispose of it. 5 to dispose.
Suppose item
4. There were some decisions.
my lord,
Item number
this
4.
was listed as a for delivery. That's wrongly,
No,
I
it's
think.
wrongly listed.
Wrongly.
Item number 4.
My lord,
Any
my learned friend wants, my lord.
I would be seeking a 1 week's time just to go through some of those issues.
because
Otherwise, on the last occasion, I had submitted that statement to indicate that.
my lord,
during the
that
PF
statement I've after instructions.
what is it?
That doesn't show, my lord, in fact, this is a individual, this is a statement in respect of individual account.
No,
It
the
doesn't show.
only issue now that is to be decided,
Yeah.
whether they had made that 8.33 along with that 12% in the person's account. If that has been made, that's the end of the matter.
So far, my instruction was, my lord, not so. And, my lord, in fact, there are some developments also. They also, my lord, asked for exemption of from the PF scheme. That exemption was
instructions I do not
granted, and then it was
Something
cancelled.
new to me.
They filed a writ petition was dismissed. There is some.
Why these are not before this court?
Anyway, but they will have to comply with. That's what I indicated. Anyway,
Bring it on record.
no, this is some petitions are also pending.
Because their stand is we have paid that 12% inclusive of
No,
8.33.
that my instruction is otherwise. Well, my learned friend wants time. Okay, well, let it, because he wants to go through the relevant provisions of the act and the scheme also.
No. Last occasion we had directed them to give the papers to
That I
you.
have given to him. He
That
has got to it.
photo designing.
No. That papers I was directed
That is a statement in respect of an individual account
Hmm.
from 99 and for 2 years. Scheme is from 95 to 2012.
then, Mr. Sharma.
Yes, Lord.
This is not done. You will have to give him the full details.
No, what we were able to collect was 1999.
99, the scheme is over. He is retired.
No, 2002 he retired.
Retired, but it came.
The period was 95.
No.
2002.
95 to
2002.
2002.
When,
Where the Supreme Court
came.
order was of 2003.
Yes, Supreme Court order came in November 2002.
He
So-
retired before that.
He retired before that.
So till his retirement, from the date the scheme was in operation, where were you depositing this money?
That's
Yes,
fine.
in his PF account, and for that regard, I have been able to bring out 2 copies of statement of the year 1999
From
2000,
95,
and 2000. These documents are very old documents, so I had asked the department to collect these
you
documents.
will have to show because
What?
your stand here is
Yes,
that this money we are depositing.
yes,
If that be so, we will not trouble you.
exactly.
But if you have not deposited, if
When-
we can't come to the conclusion, we will direct you to pay with interest.
Yes, I have
And
been
my
able
lord,
to produce.
On the contrary, my instruction is, in respect of other employees, I have got a statement. They have deposited 8.33 from the other employee, 95 to forwards.
It
So
was
it's not,
also
In your account.
no,
8.33, where? In your
pension
account?
account, our account.
Your
pension
account.
Pension.
It cannot be
Anyway,
because
my
there was a stay order at
let him-
point of
Uh,
time.
In terms of the earlier
Also,
directions.
kindly peruse this document.
No, we'll not peruse anything. Mr. Roy has to satisfy. First his satisfaction, then our satisfaction.
Yes, Lordship.
That's a public interest.
Yes, yes.
It cannot be paid. There was a stay order. Why will you
Only
pay?
thing you can get out is if you had deposited
Right,
that
right.
8.33 in his account, he took it. That's the end of the matter.
That's right.
That is my specific instruction, and to prove that, I have got for 2 years, the statement is there, which indicates the main money was
Mr.
paid.
In terms of the earlier directions passed by this court, white order dated 2/5/2024, Mr. P.K. Roy has received Miss
In Chakraborty.
A. Chakraborty, assisting Mr. P.K. Roy, Learned Standing Council EPFO, has received instructions that the amounts as claimed to have been paid is disputed by the respondent organization, and accordingly, he submits that further materials would be required to be furnished by the petitioner organization for satisfaction of the fact that the 8.33% of the employer's share, which was to be deposited in the pension scheme, was deposited by the petitioner organization in the PF account of the petitioner. Also, accordingly, list this matters again on. They'll give you some time
Yes, that's better, my lord. Let him know.
on 6/6/2024. Mr. Sharma shall furnish the above required information to Ms. A. Chakraborty within a period of 10 days from today.
Yes, sir.
And thereafter, the instructions as may be received from the respondent number one organization shall be placed before this court
Lord.
by Ms. A. Chakraborty. Full stop. List this matter, 6/6. This matter will not be considered as a parted matter. If it comes back to me, I'll look at it.
For 2 years, I have otherwise submitted before him. For 2 years, during that period. I
Will not do. The dispute is that they say you have not neither deposited there nor here. We don't have the person before us.
2 years indicates that I have paid in between 2 years. That why will I not pay for the years prior to that?
That you will have to satisfy.
That's
Mr.
why I'm
Thomas, because your contention is we have been regularly deposited.
Yes,
And they are disputing that.
no,
So we'll remit you to the civil court. You pay him, recover from the civil court. Pass that order.
I have no. I have asked the corporation to take out all the papers, but in old documents.
Oh, no problem.
some documents-
We will ask the corporation to make that payment and then you proceed to that man.
Yes.
Wherever he is, recover from his estate.
I will take this opportunity and let me find out the papers. Oblige, Raj.
Because we proceeded on the fact that 8.33
No, that's
was
a
given.
fact.
If that be given, why double entry?
That's a fact. 2 years indicates.
And my
that's
lord,
a
the
fact.
scheme
But
is such,
Satisfaction should be of Mr. Roy.
and my
not
lord,
this court
I will
person.
have to satisfy.
Ah,
and my
I
lord,
will
the
do that.
scheme is such that the pension has to be given to him irrespective of the dispute. Irrespective of the dispute.
get it?
That he has already received.
No, if the person is entitled, we will give him. But if
No,
he
he has
has
already
already
received
enjoyed that benefit,
No.
we will not permit.
Now it's a dispute between the organization and the corporation. Person
Not
has
the
already
dispute.
received the money.
Dispute is you have to satisfy. You can't bring just 2 years from somewhere and say we are paying. No.
Between that period only I brought.
95 to 2000, the date of
2002.
retirement.
I brought for 1999 and 2000.
And if it comes back to me, Mr. Roy, next time you make a categorical statement or file a 2-page affidavit or get a letter
Well, it's better.
from your
Like,
competent
I
authority,
written instructions.
we will get hold of him. Ah.
But item two, it was fixed for orders for lodgement in different dates.
Which one?
Item two,
Item 2, we will pass orders. Don't worry.
Lot.
We'll pass orders. I'll give a date.
a lot.
Top of the list, item 8 to 10.
Five minutes, 10 minutes.
My lord, I beg to my lord submit one judgment, my lord. In this, my lord, Gogoi, my lord, not here, and in this case, my lord, he has also not filed affidavit in last one, my lord.
Hmm.
Lordship, I beg to my lord refer my order passed by this honorable court is the last item, my lord, new item. In this judgment, my lord, just paragraph, my lord, 8, my lord, 8 and 9, my lord. It is not so much relevant, just to show, my lord, my lord, how, my lord, the roster should be maintained, my lord. Paragraph 8 and 9, my lord.
Anything more?
my lord, now, my lord, in the, my lord, my judgment paragraph, page 29, my lord, in the last item, my lord, new item.
আরো একটা আছে দেখছি।
Yes, my lord, WPC 4887.
4887 4887
I always, my lord, targeting my place, my lord, 12
Okay, page
page, my lord, 29, my lord. In WPC 4887. Just kindly, I may be,
this is that judgment.
yes, my lord, kindly, I may be allowed to read out this small paragraph, my lord.
Where?
Paragraph, page 29, my lord.
Mr. Borbia.
Mr. Borbuya, learned counsel for the petitioner, submits that under the Assam Scheduled Caste and Scheduled Tribe Reservation and Vacancy in Service and Post Act 1978 Act, 7% of the vacancies required to be filled up by promotion to the reserve for the candidates belonging to the SC category. As per 20-point roster provided in the schedule to the Act, the 3rd and 12th, I am 12, my lord, vacancies are earmarked for SC candidates.
This is your submission. Come to page 31, court's direction.
31, my lord.
In view of the above, respondents are directed to consider the promotion of the petitioner to the post of so-and-so in accordance with law within a period of 3 months from the date of receipt of a certified copy of the
Yes,
law.
sir.
One part.
Yes, sir.
Second part.
Yes, sir.
Respondents may also.
Mail, sir.
Yes.
Now, my lord, the findings of the court, page 30, my lord. Page 30, my lord, submission made have been considered, my lord. Section 5 of the Act provides that 7% vacancies to be filled up by promotion are required to be reserved for candidates belonging to SC category. As already noticed in the 20-point roster, as provided in the schedule to the Act, the 3rd and 12 vacancies are earmarked for
Okay.
SC category.
Got it.
Now, my lord, Lordship, kindly have a look. My lord, there, my lord, contention in the affidavit, my lord.
In this case,
Yes, my lord. In this case, my lord, Lordship, kindly have a look, page 22, my lord. This is the, my lord, roster of the, my lord, Assistant Commissioner of Taxes, my lord, where, my lord, I am deprived, my lord. Here, my lord, these posts are filled up, my lord, page 22, my lord. In the judgment, my lord, it is noticed, my lord, serial number 3, my lord, Rajendra Prasad.
have you made him a party?
No, my lord, I am showing, my
Have
lord,
you made him a party?
my lord, my lord, Lordship, kindly have a look, page
Have you made
22.
Rajendra Prasad and that person a party? Here,
No, my lord.
how will we, when they are sitting there, how will we dislodge them? We'll have to dislodge them.
Therefore, my lord, court has provided that, my lord, notional benefit to be given, my lord, without disturbing them, my lord. Because, my lord, Lordship, court found, my lord, 2 posters still
Rajendra
vacant.
Prasad and
Serial number 3, my lord, I am not on that, my lord, because he was deprived in the year 2005, my lord.
Continue what you were on. Rajendra Prasad and serial number.
Serial number 3 and 12, my lord. 3, my
12
lord, I am not on 3, my lord, because I am second senior SC candidate, my lord. Therefore, I am stick to, my lord, 12,
Mr. Borbia,
my lord.
first and foremost, these 2 persons are sitting. Right? There is another person above you who was promoted in 2011. You have not assailed that. We can't take you over Mr. Padmadhar Das and place you because Padmadhar Das was never directed to be placed from 2009.
Right.
This court, 2 parts. 1, promote him, which they have done. 2011 onwards, you cannot be promoted because there is a departmental proceeding against you. So, without crossing that bar of 2011, how can I take you to 2009?
Because, my lord, with all respect, my lord, when, my
No,
lord,
without respect, can you make submissions?
yes, my lord, I was deprived, my lord, in the year, my lord, 2009, my lord, on date is, my lord,
Okay,
my lord,
done.
therefore,
We'll consider. We'll consider.
my lord, I approached, my lord.
Heard Mr. A.M. Borbia, learned counsel for the petitioner, 8, 9, 10 day. Also heard Mr. Gugoi, you are appearing for?
Finance Taxation Department.
Who is appearing for the taxation? Heard Mr. B. Gugoi, learned standing counsel, finance and taxation, finance, bracketed taxation department, appearing for the respond number 1, 2, 3, and 4. Also heard Mr. Who is appearing for the AG? Mr. Debasis Bhattchaji for AG, And Mr. R. Bro. AG, you are paying. Your name? Huh? C. Borwa. Mr. C. Borwa.
10, Lord.
Huh?
Item number 10.
Item number 10. Mr. C. Borwa, a learned standing counsel AG, appears for the item number 10. Okay. And other two? Just find out who is appearing in the other two and just give it to him. Hearing concluded, judgment reserved.
Lordship, just my lord, one thing, my lord, in the page 30, my lord. Here, my lord, this court also observed that, my lord, on that day of judgment, my lord, there are, my lord, 2 posts are vacant, my lord. And the
When? That is not mentioned. When?
my lord, page, my lord,
When it is vacant, that is not mentioned. Is it vacant from 2009?
no, my lord, it is
Yes, Mr. Gugoi. Why are you not giving him? Give him.
only, my lord, I am, my lord, insisting, my lord, praying, my lord, with all the respect, my lord, just notional, my lord, nothing else, my lord. Notional benefit, kindly, lordship may consider, my lord, he is an old person, my lord.
Reserve your energy.
Yeah.
You will require it.
Item 11.
Oblige, my lord.
Yes.
Well,
Mr. Farah.
here I have received only one signed copy of the report of the GLC. Madam.
Huh, where is it?
And my lord, particulars of the teachers madam, who were recommended. Madam.
What is this logic?
My lord,
What is this logic?
my lord,
Who has written this? Your district elementary education officer.
my lord. This 21/3/20.
I'll note this. I'll copy it in my order. And this will be the thing we'll follow now.
My lord,
Headmaster,
my lord,
100 students not there. Even if he is teaching SMS, we will regularize, provincialize.
otherwise, my lord,
And all those provincialization which you have done,
my lord.
ignoring this position, we will ask you to now redo that.
Then, my lord, this private.
Have you got a copy of that letter dated 21/3?
Yes, I have, my lord.
See that?
My lord.
1, 2, 3, 4, third, Anand Pine.
Ananda Paying as
Been
headmaster.
recommended as headmaster of so and so as per government circular. Also, the headmaster here recommended against Eastern is eligible for teaching other subjects
My lord,
other than language and science.
my lord.
What is this logic?
Except like.
Where is that particular submitted by the headmaster himself? It's on record.
That is, my lord, page 23. And except 4 of the 8th edition, my lord.
SMS. Then what is this?
My lord, here, only
Huh?
Nilima Bora is junior to the petitioner, my lord.
Be that as it may. That is language.
My lord, true, my lord.
So, Anand, why Nilima Bora has been provincialized and not your Ananda Pang, SMS teacher?
My lord.
Huh? Now, Nilima Bora Hindi.
Hindi, my lord.
Then in other schools you say Hindi. No, that is it.
No.
Language we will not provincialize. Arabic we will not provincialize. Assamese, we will not provincialize. What is this? What is so special here?
As per my verbal instruction, my lord, in the Jorhat district, my maximum provincialization recommendation of these as per.
Jorat is not within your control.
No, my lord. That's
It's not within your control.
within
What is
our-
this?
Only
Apparently, he has been
my lord.
denied. Who is the Lord Counsel for the petition? P.K. Das. Mr. P.K. Bora, in terms of the directions passed by this court as placed before this, has placed on record the instructions as received by him in the matter, and the same reveals that the same also includes a communication dated 21/3/2024 issued by the District Elementary Education Officer, Jorhat, wherein justification has been advanced with regard to the provincialization of the services of serving teachers of prevailing missing Janajati any school was services. Also, on perusal of the same, this court is not satisfied with the justifications as so advanced therein. Also, accordingly, the Director of Elementary Education Assam is directed to examine the issue and furnish her views in the matter in writing through the standing Mr. P.K. Bora, Standing Council, Elementary Education Department. List this matter again on 4/6/2024. Ask them to redo. Otherwise, if we have to enter into this, it will be bad for you.
My lord.
Also on item 12.
Obliged.
None appears for the petitioner on call. On the last occasion, the instructions as received by Ms. P. Das, the Standing Council for Secondary Education Department, was kept on record, and the Learning Council for the petitioner was absent on account of certain personal inconveniences. Also, this court had earlier directed the Learned Council for the petition to make her submissions in the matter. However, there is no representation on behalf of the petitioner in the matter today also. Ms. L. Valjida, on the issue of maintainability of the repetition of the record, directed to make submissions on the issue of maintenance. What to do?
This is second time we not appearing. Second time they have not.
Okay. Eto rakit hoba, second about, mane jodi hoy, second about what? We'll call it about.
For admission, item 13.
None appears for the petitioner on call. So this matter will not be treated as a part of registered to list the matter after 3 weeks on a date to be fixed by.
Item 14 to 16.
Mr. Monta, I've gone through the whole thing. Nothing is there. Nothing is there. Can't help it. We'll have to close this matter. But there are 2 other matters tagged to this. 15 and 16.
Other two, they are
We'll have to,
regulation.
we'll have to segregate those.
They are regulation.
Regularization,
nothing to
so
do
we'll
with
have to
the-
segregate that. And this matter, we are disposing it. Item number 15 and 16 together.
Fifteen and sixteen, these are no,
Regularization.
Regular.
See,
because they are still working, they might
ah,
ad hoc probably.
item number 15, 8073, 2019. The issue as raised in the present proceedings pertains to the grievance of the petitioners hearing of their services not being regularized in spite of the fact that they were recruited, albeit against against they were recruited through a process of regular selection, but appointed as guest faculty public part-time staff in Barak Valley Engineering College, Karimganj. Also, the issue as arising in the present proceedings has no connection with the issue that is that arises in WPC number 6005 public 2021. And accordingly, the present petition be segregated and listed separately. After 2 weeks, on a date to be fixed by the registry. 8795. The issue as arising in the present proceeding is with regard to the grievance of the petitioners of non-regularization of their services in various polytechnics of the state, wherein the petitioners contend that they were recruited by following a process of selection, but were appointed as guest public part-time lecturers. Polytechnic, newly established polytechnic school. Also, the issue as arising in the present proceeding has got no nexus with the issue arising in WPC number 6005/2021. Accordingly, the present petition stands segregated and would be listed separately by the registry after 2 weeks on a date to be fixed by. Mr. Monto.
Hello.
Here, you, in case of non-technical, you were able to publish that list and then take the matter forward. Here, the list is ready, but you have not formally published it because the leave was not done. That's the situation. And thereafter, because of the interim directions passed by this court, my Lord Justice Pathak, that matter was stagnated there.
My lord.
And this court in that other
No,
IA had permitted you to go ahead with
already,
the,
your lordship,
no,
yes,
non-technical
already
and you
interview
have-
is held. Interview.
and Mr. Amit, we have gone through. We have gone through the materials Mr. Monto had placed before us.
Yes, sir.
9 petitioners admittedly have not qualified the language
Language.
test. So their cases we cannot consider. As regards the other 10, 8, there are ladies. There are petitioners who have appeared in 2 different departments. This is the fact.
Yes.
But in neither of these 8, they have got the qualifying marks. Right?
Yes.
So they cannot be considered. There are 2 petitioners who, according to the APSC, on scrutiny of their records, it has come to light that they don't have the eligibility or the educational qualification as mandated in the advertisement. So their cases were not considered. Right?
Yes.
In that view of the matter, we will now permit the APSC, modify the order to proceed with this election and take it to its logical conclusion. Now that these materials are not before you, you
Yes.
don't know what it
Yes,
is.
yes.
And this will come to your knowledge. We'll not make any observation, cut-off marks, nothing we are going to make. This will come to your knowledge only after the
Result is there.
result of this election is permitted. And we permit you, we will give you a liberty that individually, if you have any further grievance with regard to the marks given to you or the question raised with regard to your eligibility, you are free to take whatever legal recourse it's open to you. That will do.
My lord.
My lord, just before your lordship passes any order, your lordship please kindly sometime so that when the senior counsel should ask and apprise this before passing any order.
We are passing.
Yes,
You can get Mr. Das
yes,
after 10 minutes.
yes.
We'll have it after 10 minutes.
Fine.
You can apprise Mr. Das of
Yes.
what has.
He's on his way.
And Ms. Sharma, you please be ready with that seal cover thing that Mr. Monta has given me. While I dictate, if any error is there with regard to the naming of the petitioners, petition numbers, kindly correct.
Yes, detail.
10 minutes, 10-15, Mr. Dotto, 10-15 minutes, let them. And there is one issue. In one of the matters, we had directed that if you don't take leave, Netramoni, I suppose, that is for Mr. Gogoi. We will not touch that. We have segregated that
My lord.
because in the earlier order, we have said that even if appointments are made, because that leave application is not filed, there is a direction that their services should not be disturbed without leave of
Because they are working in ad hoc.
ad hoc. So that we will not touch,
My lord.
right? We'll keep it at Mr. Gogoi can file an application because once Mr. Monto
Result was
out, you can come and
Our
application will consider
selection.
selection
Appointment is.
because that part we have not touched because there is an order of this court and there is no application.
Item 17 and 18.
Wait, is the lordship. My lord, in this matters, my,
This is with regard to that.
yes, my DO appointment, my lord. I'm led by Mr. K.N. Sodo in this matter, my lord. I pray that a matter may be taken up some other day, my lord. You will address your lordship.
Any objection?
My lord.
Have you informed them?
Time, Lucio.
They have not informed us. As again, respondent number 11, it may be dismissed.
Mr. Dick, whenever there is a senior counsel, boy, even they prepare.
Yes, my lord.
At least you could have told them yesterday night.
That is why I did not make a mention at 10:30,
That
my
time
lord.
they could have utilized for some other thing.
Yes.
They all prepare. You also prepare. You will also not like it.
It's all on my
As
part, my
against
lord.
the respondent number 11, there is nothing, my lord, they are saying. that-
I've seen.
So that should be, my lord, dismissed with some cost to the petition.
First, get this court to open the brief, then after Anyway, when do you want it? Settle a date.
Next week, my lord, if any convenient date of my senior.
We have, but the only thing is that if you have do not.
On the prayer of Mr. R. Dekalana Council appearing for the petitioner submits that on account of certain personal inconvenience of the argues, the senior counsel, Mr. K. Chaudhary, the matter be taken up on another date as agreed to by the parties to the proceeding. List this matter again on when, Mr. Das?
Any date, my lord, we are always.
21st, my lord.
On 21/5/2024.
Lordship,
Also, no further adjournment.
Lordship,
Mr. Das had submitted urgency in the matter and accordingly, no further adjournment would be permitted in the case.
My lord.
Lordship. Mr. P.P. Datta is appearing in this matter, Lordship. On 21st, he has some difficulty, Lordship.
He would be required. We'll have it on 23rd is a holiday,
30, my lord.
28.
Lordship,
28.
much obliged.
28, and deeply obliged.
17, 18 also same order.
Similar matter. my
Same.
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 17.
I am deeply obliged.
Supplementary item 23.
Mr. Das.
Yes.
Today we have time, so let me just finish up the
Fine,
list and then come.
fine, fine. Deeply.
Get Mr. Kayal also.
Yes.
He'll be arguing.
Yes.
Hearing better kita mati. Yes, orders. Hello, dispose ko ko lagi.
For orders, item 19.
Wait. Yes, desired.
No competition, Mr. Burwa today. I'll hear it, but again, get hold of them.
I'll get.
Burwa sa matlab. Oh, orders kita.
Supplementary orders 24.
May I please your lordship? Lordship, this is a.
We are not convinced.
Lordship.
We are not convinced. This issue cannot be decided here. You will have to go before the
Lordship,
tribunal.
the grounds I have stated.
That is your grounds.
Lordship.
We have decided that matter from the point of view of the petitioner therein.
Lordship.
We find he did not have a case. Disputed issues. So we have asked him to go to the tribunal. You're holding the post?
No, Lordship. Nobody is holding the post.
Then?
Lordship, the issues.
See, how many litigation before this court till now?
Series of.
One you, then he comes, he finishes, you come.
Lordship.
Every case, directions issued, but subsequently something else happens.
Lordship.
So in that view of the matter, why should we entertain
Lordship,
this?
the issues that were raised, Lordship, that has already been decided by this honorable court. And again, the same
We-
issues were
we
brought
have-
by the
You have
impugnant.
filed a writ petition.
Lordship, we have filed already pending.
Okay,
Lordship.
what is that number?
Lordship, that is 6786 of 2023.
Miss A, Miss A Talukdar and a counsel for the review petitioner. Miss Talukdar submits that the review petitioner has already approached this court by way of filing WPC number
6786
6786
of 2023. Lordship.
2023, and the same is pending. So accordingly, registry is directed to list this review petition along with a WPC, along with the said petition on 4/6/2024.
Much obliged, Lordship.
Item 25.
Yes, Mr. Das,
May it please your lordship.
you sleep, let things happen, and now come and file a review petition.
No, that is one aspect of the matter.
What is the other aspect?
The other aspect is that before I take your lordship with the papers, my lord. My lord, this was a case wherein on 14th.
You tell me one thing, I may be wrong. LDA to UDA.
Yes. Yes.
You gave a letter saying that I don't want this promotion. The other person promoted. Subsequently, another vacancy arises and you submit an application. Now you are also promoted. Now the rules that are holding the field says a person who has been promoted earlier will carry seniority. In that view of the matter, forget the subsequent gradation lists, forget everything. In that view of the matter, what is the error?
That is what your lordship has decided in the writ petition. Now, it is a case wherein the applicant before your lordship, she had foregone her promotion. Now, that letter is dated 14/6/2016. Now, foregoing of promotion, as we have understood, as I understand, my lord, is that you have been offered a post, you have been offered promotion. I'll come to that, my lord. You have been offered promotion and you are considered. After that, you said, I have got, my lord, this is a case of serious mala fide against respondent number 7.
The review to do, okay?
After that, applicant has said, no, I have got personal difficulty. I don't want this promotion.
Review.
That is a case of foregoing promotion that I understand, my lord. Here the facts, the very important fact which was not placed
before this honorable court by the official respondent.
A item number 25, to repetition, review to. What was not placed?
Not placed before this honorable court is that the vacancy against which this entire game was, my lord, plotted surfaced on 16/10/2016. My lord, I cannot conceive of a situation obtaining a letter, my lord, foregoing promotion 4 months prior to arising of the vacancy. I cannot conceive of a situation, my lord. You offer me sweet, I say I won't take sweet because I am suffering from diabetes. But I cannot conceive of a situation that vacancy will surface on 16/10/2014 after promotion of Navadurga Goswami, and on 14/6/2014 he will obtain an NOC from me.
You gave your NOC on
14/6.
whatever it is, 14/6.
2014.
Huh.
Thereafter,
Huh.
another important fact is that on 19/6/2014, I submitted a letter to the principal saying that I want promotion to the post of UDA. What happened to that letter, my lord? Why that letter was not placed before the...
Because this recommendation, okay,
Why that letter was not produced before the GB, before the DPC?
the council did not place this before this.
Exactly, my lord. This was the most vital document. Another aspect, my lord. My lord, as per the rule, a person has to be on a probation period of 2 years. The respondent number 6, he was initially appointed in the year 2012. That is on 14/3/2012. There was no confirmation order that was placed before.
Where is your confirmation order?
Sorry, my lord.
Your confirmation order.
My lord, I got initial appointment on 1/2/2001.
Anyway, then there would have to be a confirmation order in your case also then.
My lord, my confirmation order is there, my lord. Lordship will find.
The person has been already promoted as head assistant.
No, my lord. No, till date, no decision has been taken. My confirmation order, page 37A of RA 87/24.
37A.
37A. Lord, had these facts would have been placed before your lordships, my lord, perhaps, my lord, this honorable court would have come to a different conclusion. My lord, I allege serious malafide against respondent number 7. My lord, this honorable court was pleased to, my lord, overlook or, my lord, that was skip the mind of this honorable court because he said denial. My lord, malafide I cannot prove to the hilt. That has to be, my lord.
The materials produced before this court on
At that
day,
point of time, absolutely.
this thing
Never
never have been considered.
Never.
Because if you had submitted that application under pressure, and it seems that you have a lot of experience working as an LDA in the department, at least you could have objected that this was taken from.
Exactly, my lord.
That was never done.
If I, my lord, take it as otherwise, if I would have submitted that 14/6 voluntarily, why would have submitted 19/6 letter? If we appreciate, my lord, if I submit other way around, why would I submit on 19/6 if I was so voluntary and all these things?
We will not make anything. We got your point.
Yes.
We will issue a notice.
Yes.
Get the notice served.
Yes.
Bring him.
My lord.
And then we will consider.
My lord. In the meantime,
we'll finish it up then.
In
the meantime, anything happens, that will be subject to this. Well, I'll make that up.
Yes.
But Mr. H.K. Das, Lana Council for the review.
No exercise has been done as of now, my lord.
Because there is an order.
Yes.
This was passed on the materials as was found valid with your submissions. Even your submissions were taken. So we will, the subsequent material, let us test it. Let them come. we'll have it on the same day, we'll dispose it of.
Fine.
Heard Mr. H.K. Das, Learned Counsel for the petition. Also heard Mr. S. Das, Learned Standing Counsel. Education, Higher Education Department. So issue notice, returnable 4 weeks. Petitioner to take steps. Mr. S. Das accepts notice on behalf of respondent number 1 and 2. Petitioner to take steps for service of notice upon respondent number 3, 4, 5, 6, and 7 by registered post with AD. Full stop. On the returnable date, the also issue notice on the prayer for interim relief. Returnable. Also 4 weeks. Also. Any promotion of the respondent number 6 to the post of head assistant, if effected during the pendency of the present proceedings, shall be subject to further orders that would be passed in the matter upon hearing the counsels, upon hearing the parties to the proceedings. Full stop. List this matter again. Today is
For
list
status.
this matter again on 3 weeks, 4 weeks. 18/6.
Or a status quo would have served the purpose.
Because I have a reason for that. On that day, this matter was deliberated.
Yes,
These issues never was placed.
never was placed.
So we will not go into.
Fine, fine.
Item 26.
DPO.
Yes, Mr.
26 item.
Same.
Same.
Uh,
This is against the
88 not-
repetition.
88 not,
File.
along with 87 going. Same date, same date. Same
Item-
order, huh?
Item 14 to 16.
No. Hey, Barbara sir, Mr. Das,
Time, sorry.
just finish up with Mr. Barbara and then come back to you. 10 minutes ago.
Item 19.
19, 20.
20.
This-
Item,
this-
item 20.
My lord,
Have you gone through it?
I have gone through it. My lord, I think the matter can be disposed of today, sorted out. More than your lordship, it is difficult for me to convince Secretary.
Hmm.
I convinced him.
That Chetri will never be convinced. We know that.
So about that thing, whether in a service matter, he can be, I am not pressing. I searched for it. There was a judgment by Justice Biplab Sharma. That was not my lord ratio decidency. That one sentence in service matter, no substitution, like that. So ignore that. We may ignore that. my lord.
Because Mr. Barbara, why I said so. Substitution, if it was something which
No.
will go with him, then we will not permit that. But here, if the matter goes in his favor,
Yeah.
the person, original petitioner, stands to gain. That gain will now come to
Yeah,
the
it's all right. Because money is involved there.
management.
Area salary, and I don't grudge him getting money. I don't grudge him getting.
And at the same time,
Yes.
we cannot give him
And
money
Moreover, that
illegal
man,
manner.
unfortunately, he is no more.
No, his family also, we cannot give it to her
Right.
in an illegal manner,
Right.
in a manner known to law.
My lord, actually, so that question is apart, my lord. Let them be substituted. They have been substituted. It's all right. Now, for his satisfaction, what I was preparing, what could have been argued by us if we contested. I am not going to. That he never challenged the seniority list for a long period of time. And didn't file any objection, first of all. For about 30 years after, he comes to this court and claims his seniority. It has become a stale matter, my lord. A number of decisions. He was in deep slumber for 30 years. I will not show those decisions. I tried to go through this about the matter, my lord. In a number of cases, in a case, Supreme Court said rib bhang uncle in slumber. Rib bhang uncle in slumber. So one cannot put forward a stale claim like seniority in an already settled matter. What? If it would have been a promotional post, fait accompli. Fait accompli. After 30 years, things become fait accompli at times, irreversible. I am not pressing for that. For his satisfaction, I am arguing. It becomes, my lord, a fait accomplished
Then delay and laches also there is no whisper, it defeats equity. Then clause 124 of the Schedule to Limitation Act, reviewed. But I don't want to put all these objections, if at all, my lord, for us, there is a lawful way out. And I am coming to that.
That you show.
The question of inter-se seniority between both of us has become a stale issue now. This is only in the papers. More so after his, my lord, demise, unfortunate demise. So as I said, my lord, I don't grudge him or his heirs apparent getting the area salary. Hence, no more going into the academics and substitution of the review, which I raised on the day. In fact, I didn't object it.
No.
I didn't object, I raised. There were a break-in service for him also, forget. Both were joining on the same day. Both joined on the same day, and rule said date of birth. Thereby, he is, my lord, senior. I cannot object to that, my lord, date of birth, my lord. So he is senior, but and rightly pay scale also same for both of us. For both of us, it was a stagnant post. It is not a promotional post. That is a teacher, retired as a teacher. So what remains there? Moreover, only in 2013, both of us were provincialized, my lord. So without completing 20 years of service, we don't get pension. Only the area salaries. Now, my lord, the question is, I am also same day provincialized, same day joining when we are not provincialized. I am also entitled to my area salaries with respect to the sum period, which is, my lord, to my instruction is under process. And lordship may kindly make a, my lord, indicate about that. Let him get his area salaries. And
But how?
he will get, my lord, your lordship will review it.
I got it. But
Review it. And
after review,
in a review petition,
I will have, it will be either Mr. Purkhaisto or Mr. Chetri. Both cannot be there.
both cannot. No, but both cannot be.
This court, that direction this court passed, error.
Yeah.
Because once the provincialization is done with, then that school is no longer covered under the 2011 Act. It will be covered under the 2003 rules. So those posts, now we cannot direct him to be accommodated. Because if we do it, that will be an erroneous
Only,
direction.
my lord, realistic question remains area of salaries. Nothing more than that, my lord. Seniority is also gone. It is only a paper.
It's only a question.
So what I
senior,
suggest-
it's only a question that whether Mr. Chetri was required to be provincialized or Mr. Purkhaisto was required to be provincialized. This is the issue which is there before this court. If we hold Mr. Chetri is there, fine, that's the end of the matter. But if we hold because of the findings that are recorded in the order, which now review is sought for, then we will have to say that order was erroneous.
My lord, in a review petition, lordship may review means what? Rectify and modify. Lordship may modify here one, there one. That's my suggestion.
But I want a way out.
No, because
If you,
No.
Mr. Baba, your submission is that by giving him his benefits, Mr. Chetri should not be disturbed.
disturb.
That
is
that boils
that
down
is-
to that.
Let him get his area salary. Let
How?
me get
From
my.
where will the government pay his area salaries?
Let him get his
From the
area
same
salary.
post, 2% cannot be paid.
But both were provincial, my lord. The fact remains that both were.
But his provincialization was,
Maybe, my lord, one day before or the same day, by going by the date of birth, he is senior. But me too, I am entitled to area salaries just like him. So there your lordship may take care of both the things, my lord, about his area salary and my area salary. But actually, we are not at lower.
there's no post, that's the problem.
What lordship is thinking, madam, I'm just adding, my lord, seniors. There is also direction in the repetition.
That is what is troubling me, that Mr. Borbora has understood. That is what is troubling me, that how can that direction be given to provincialize him against a post which is no longer within the purview of the 2011 Act, Mr. Baba.
This accommodation, my lord, for respondent number 8.
No,
to
no,
accommodate him.
Subject wise provincialization
It's
is not a problem. He may be, I may be Sanskrit, he may be Hindi, I may be English, he may be geography is also not problem. So there, that way, my lord, your lordship may sort it out. Whatever.
At that point of time, Mr. Borbora, Mr. Purkhaisto also, how many posts were sanctioned?
Four posts.
All the posts, my lord,
Three.
Sanction, whatever as per the format of the 2011 Act, my lord, all these posts are sanctioned in respect of.
Then two retired, my lord. Two retired. Post fed.
That is the problem.
They are where,
But
my
we
lord.
cannot take note of that.
Yes.
Where is that order? Provincialization order?
Page 44, my lord.
Take me through that now, sir. You are at serial number 4
Yes,
and Mr.
Seven.
Lukman Ansari is serial number 7,
7.
right?
Yes.
Thereafter, what happened? Where is the subsequent action which required you to come here? Or Mr.
I have not come. He has come, my lord.
Huh?
He has
Yes, come. I know that. Why? So 74 is the triggering of point for him to come.
In judgment under review, page 166, Lordship see. It mentions about my lord adjustment against the retired, I mean those who died or retired. Last paragraph of the judgment. 166. It is written there. It is the findings.
And the government has not done this.
No,
Cannot do it.
no.
Cannot do it. That's the problem.
So that is the way out, my lord. That may be the way out.
And what was the subject you were teaching?
Arts, my lord.
Arts.
Yes, sir, arts.
Mr. Professor,
Yes, sir.
one factor. Where is that original page 74? No, page 46. This is the original provincialization order.
Yes, yes.
Any person has come in or moved out of this list? No. only
He was the Sanskrit Malon
he was
and that
Sanskrit
is withdrawn subsequently.
subsequently. And then he was, but that post that was sanctioned continued.
That-
Was anybody
No.
then?
Then he may be accommodated against that post.
Yes, who is appearing for the government?
Secondary, my lord.
We got away out, Mr. Barbara. We'll do it. Can you confirm this position?
Secondary division,
Mr.
my lord,
Chhetri,
I cannot.
if you come to page 46.
If he is accommodated against the original post, my lord,
That post that was created, that is the end of the
then he
matter.
can get the salary, my lord,
Ah,
and I can
and
get
you
my,
get it.
yes.
But I only want to know whether any one of those posts,
Nobody has
somebody
been-
had gone in and somebody had come in.
It is sure that nobody is appointed.
Nobody.
Nobody is appointed, sure.
Then why it is hangama? This can be done like this. It did not click to me on that date. Just now it clicked. If there are 10 posts sanctioned
Yes,
and there are 10 persons who are claimants, there is no 11th person. So there is no occasion to either remove him or Mr. Chhetri. But I want a confirmation on this.
confirmation
you-
with regard to appointment, I am sure that there was no appointment.
Mr. Chhetri? Mr. Chhetri does not seem to be very happy.
Never. No,
We'll get-
if he gets otherwise without.
No,
disturbing-
I don't want, I'm not on that, Mr. Chhetri. I want this. If there are 10 posts created, 10 persons are only the claimant, only because of the fact that you are Sanskrit, you should have been Hindi,
No, no, no.
you need
I'm not
not
a
be
Sanskrit.
troubled. Yes, Mr. Kaushik is here.
I'm the assistant
The
teacher.
creator of the problem is here.
Yes.
Mr. Kaushik, do you know about this factor, this case? Just have the repetition. Come to page 46. Or you can come to 44 also, it's better. Now, now these are the 10 posts that were created. You got it? Now, if you come down, respondent that serial number 4 is the review petitioner. He is an assistant teacher arts, right? Serial number 7, Lokman Ansari is Sanskrit teacher, right? Now, this position, there was no dispute. It continued as such. So 10 posts, 10 people. Now what happened was,
Again, the letter was written by the headmistress, madam. Next paragraph.
page 48,
40.
that's what I'm trying to refer to. Mr. Chetri, just wait for a minute.
There was anomalies, madam.
Page 48, the headmistress writes a letter that Lukman Ansari is an assistant teacher. His post was approved in the internet list published so and so. He was rightly designated, but in the appointment letter, he was shown as Sanskrit teacher. So she made a query. Now this query was processed further and a statement was produced by the headmistress at page 53. 53. In the meantime, after provincialization, 2 persons retired. So their names are not there, 8 posts are there, right? Then what happened, you see? If you come to page 74,
In particular.
page 74. 74 is a order of the director.
73 here.
73. The services of Lukman Ansari, who was provincialized as Sanskrit teacher instead of Hindi teacher, though oversight, so and so, Whiteley's Office Memorandum 2329/2013, that is page 44. Right? White so and so here is hereby withdrawn as there is no provision for Hindi teacher in Hindi medium school. The district level scrutiny recommended his name as Hindi teacher of this school. Right? Now the problem starts. But this post continued in the school. It was not withdrawn. Now disputes arise, and accordingly, a writ petition is filed at page 81. Right? Some directions are passed. Now, this writ petition order is 8/8/2019. Right? Here, Mr. Chetri was held to be senior to Mr. Purkaisto. Right? Chetri is the Sanskrit teacher, Hindi teacher that case was withdrawn. Right? Now you come to order at page 86, 4/8/2021. Read the first paragraph. The service of so-and-so was provincialized earlier when the said act was in force. However, due to some reason, his provincialization order was withdrawn. His services might have deemed to be provincialized and he could have been receiving salaries had his provincialization order not withdrawn, while order dated 8/4/2015. Now in compliance of so-and-so, 8/4/15 is cancelled. Further in partial modification, service of Lukman Ansari is hereby ordered to be provincialized in lieu of Mr. Purkaisto. The post still remains there. Right? Now, being agreed by that, that was put to challenge by Mr. Purkaisto. Right? But in view of the fact that that was done in terms of an order passed by this court, at page 90, after recording that he will be senior, says that maybe this court had expressed an inability to get in when there is already an order. That is why this review has been filed. Now the question is, if that post was already sanctioned to that school, he is no longer there, he is dead. Huh? If we direct you, that post is there, we will interfere with that speaking order. Go by the first line. Say that continue Mr. Chetri and Mr. Purkaisto against their respective posts, release the amounts till the date he was serving, because after that he is dead. And Mr. Chetri will continue till he, because this is not a case under the 2013 Act that posts were created, personal posts were created. 2013 Act, permanent posts were created. 2017 Act, personal posts are created, right? So those posts continue. This court, this aspect may not have been brought to notice. This court said, now regularize Mr. Purkaisto against the persons who were provincialized and subsequently retired. That we can't do. Because those posts now will be covered by the 2003 rules, not by the 2011 rules. Can you get your instructions on that? Only thing, the posts are surviving. Right? We'll pass orders then. When can you get it? Tomorrow? Tomorrow difficult.
Tomorrow.
Monday I'm not here. I don't want to trouble Mr. Borbora by a VC.
I'll try.
You just try. If you can, just that post continues there. Don't give much details. Just have this instruction. Right? Continues there.
One is continuing, whether the.
Other one is
Other
continuing.
existing or not.
If we get it, we'll resolve it in that.
Because, my lord, as per their order, while provincial, they clearly stated the posts are allotted.
Allotted and the
With the-
director's order first line
Yes.
speaks of something else.
Actually, those
It is,
words,
they say that because of the orders of this court, they are doing it.
actually, those words in lieu of was not necessary at that time. Conflict was not there.
It would by slip kali koi.
All right.
We'll try, Mr.
Of like,
That spark you gave me, from there I started going, sir, how to resolve. Then I got that. That's it. If Mr. Kaushik is magnanimous enough tomorrow. Because he is no longer there. So there is not much outgo that will happen to you.
Provincialization order page 44, post that creation.
But
Though he has been shown as a
Sanskrit teacher,
subject teacher in the
it can be shown as an assistant teacher, we'll direct for that. But the thing is, whether that post is continuing.
I'll take it.
Hey, so we could successfully bring you here.
I'm sorry, my lord, I could not be present.
That day I told you you need not be here.
Yes, my lord, only one
Just
thing.
like, lordship would have fixed the date for segregated amount, segregated lordship methods
No, we have just said 2 weeks,
after 2 weeks.
our 2 weeks. Whenever they listed.
Lost. So, my lord, only one. Other two matters are segregated. My lord will just record my submission. That number one is saying that there is one, we said that select, there is no sanctity of the select list.
I have
Yes, just only
just noted one
refreshing-
submission against you. I've noted one submission against you.
No, it's good.
What that is, with regard to that language teachers test that you
Yes.
submitted, one. Two, I have recorded a submission. After they have filed their affidavit, and therein there is a draft fresh list published.
Yes.
It's not a list published, but a draft recommended by the committee. You have not raised any objection with that. We have gone to that extent.
No, I think objection, we have filed objection to it.
No, you have not pointed out any further person therein who is similarly situated to the 41 or the two.
No, that I can't, how can I know it? Because when I don't know what is the qualifying.
That is what
mark-
I'm saying,
No,
Mr.
my lord.
No,
my
Mr.
lord,
Mr.
kindly
Das,
see.
you knew about,
No,
or you
I-
knew
I-
someone, they have now come
No,
up.
I say, no, my lord, I raised that objection. In my affidavit, I have reply, I have filed. No, the question here is that, my lord, number one, that what your lordship has checked the records yesterday. I just wondering that if there is a no qualifying marks. I have found some 2002, your lordship had the All India Judges Case 2002. They qualified, that was a separate issue. I could not, your lordship will please enlighten what is qualifying and what is cutoff mark. This is what.
That thing was troubling me yesterday.
Yes.
How to,
Now, just
how
before,
would there be a
that,
parallel?
No,
How would be
before that-
what I have understood,
yes,
subject to whether you can throw more
Yes.
light on that. Cutoff marks is never fixed. It is a derivative from the persons, because they have two fixed parameters. One, they have a pool. Two, they have a ratio. 1:4, and they have a number of posts. These are the three fixed parameters. Now, applying that ratio, they bring in 5 posts, 20 candidates. But that 20 can go up to 30, 40 also, if there are persons who have got these similar marks. Last person got 30. So 30, if there are 10, say he is the 19th or 20th candidate, there are another 10 candidates who have got same marks. They all will have to be brought in, so that list will go till 30, although it should be 20. The mark the 30th person got would be the cutoff marks, subject to correction.
Correct.
Qualifying marks is something which is assigned, fixed, assigned.
yes.
Here, the committee sat, the selection committee sat, and they put a cutoff mark of 25. Whoever 10 petitioners, more than that. Other 9, unfortunately, below 25. That is why I was telling Mr. Ahmed,
Yeah, my lord, that means qualifying marks, they have put it 25. 25 is a qualifying marks. So one has to get more than 25.
25
So,
or more,
25 or more. If you get less than 25 marks,
out.
then you are out. Now, your lordship indicated that some of the candidates out of 19 9 didn't have the qualifying, if I'm not
Qualifying.
wrong. So that means they are below the 25.
25.
It's a prerogative of them how to fix a cutoff mark. We can't say, we cannot. enter
Qualifying
into
marks.
qualifying marks. Now, in this case, your lordship, after going to record that, your lordship has put a query now, just not that you have not raised objection to it, we have raised objection to it. The 12 candidates, my lord, will just recollect. The
So language gone.
my lord,
Now the
now,
teachers.
after the language, they have notified that these are the candidates who will sit for the interview. Meaning thereby that these are the candidates who qualify the local language test and that they will sit for interview. So at that relevant time, we were agreed. And we came up before this court. And we pointed out, look here, this is a select list which you have prepared. Some of the candidates have not been also qualified. Now, I have been told that your lordship has said 2 of these petitioner also, which is before, they
Not qualified.
That's what my learned fairness, my
Out
fairness
of the
said.
10,
Out of
8 in different subjects, different departments, 8 did not get the cutoff.
So,
And there are people, petitioners, who have appeared for 2 subjects also.
yes, no,
2
that's-
different posts also.
yes. Now,
Then there are females.
yes,
I have first gone through the merit, general, SC, different cutoff marks, took their mark, what they got, what has been disclosed. That Mr. Monto, you catch him if that something error is there afterwards. But say somebody, Mr. X petitioner, got 760 cutoff marks, and she's a lady. Cutoff marks for male general and a general candidate is 73. And for that, for maybe what you call that lady, cutoff mark is 65. Now that she got 63, naturally she will not come in. Then we went to the second subject she had opted for, if she had qualified in the language test. Therein also the same parameters were applied, and it was found that no, that cutoff mark was not reached. Now then we will go to the second part. 41 removed. 41 from
41
various
removed.
categories removed. So 41, normally 41 should come back. Then I was having a severe doubt on that. Then Mr. Monto on the last day satisfied this court because that ratio that was prescribed, that was published. Nobody questioned that till then. So that ratio, applying that ratio for civil engineering 5 posts,
no,
20
I'm sorry,
candidates.
just for a moment. That ratio, when they came up with the ratio chart, that this is, then we made a notification. We filed an application saying this is what they have to maintain the ratio. Initially, your lordship just recollect.
I've
This is
recorded
the-
it in the
yes,
other
This is,
order
yes,
also.
this is what the ratio has to be
So
maintained.
that ratio
We
is,
said-
if there are 20 posts, 1 number of vacancies. If there are 4 posts, number of vacancy. In between, there are another criteria.
So what our case was that when the chart was provided, we said that these are number of posts, but this you have not maintained the ratio.
No,
That's our case.
I've gone through that.
Yes,
5 posts, 20 should be there.
yes,
But they had 33. Out of that, 5 gone.
yes.
So it comes down to 28. 5 into 4 is 20, but still 28 is there. So they have not
Already maintained.
brought in.
That's, my lord, that's what my submission was. My lord, your lordship will kindly see into the whole selection process. My lord, it's your lordship will examine, of course.
It went through fire, and the grain and the shaft could be segregated. So if it can be segregated, we'll have the grain.
No, that is,
Shaft is already
my
good.
lord,
But
my lord will just-
Mr. Das, there is another aspect. Now, this order that I am passing,
yes,
you don't have access to the records. You will have access to the records once the selection process and the select list is published. I'm giving you a liberty that 2 candidates who they have rejected because of qualification, and the 9 candidates who two parts did not get marks in the qualifying examination and did not get marks in the OMR. This is a material which will come to you after the list is published. I'm giving you
But a
liberty.
tentative, your lordship's view will be a tentative view,
View
but it's not
only
that.
on the part, on the
not will-
materials now
not
available.
will-
on
Not
record.
will affect the merit of this particular, once.
I am
Fine.
closing the repetition, giving them liberty to proceed. They will now proceed with the matter in terms of that fresh list that they have now prepared. We are giving them that liberty, but we are reserving a liberty to you. Once the selection process is over, you can have those information, which they naturally will have to give you. And therein you find from the OMR sheet or from the examination which you took for the language, that marks were not given to you, or you were entitled to more marks. You are entitled. You will be entitled to question the selection before this process.
But this election, I found that one after one another, they were rectifying it. This is actually they should not.
Rather, this court, see, Supreme Court is also very clear. This court's endeavor should not be to do away with the selection. To the best possible extent, if we can segregate the good from the
No,
bad,
that's the all.
we have done it.
But one matter now.
The
I don't
fire
know.
puring of the gold,
But
gold impurity is
matter-
gone. Now we have
Now,
24 carats.
now one matter which is pending for Supreme Court, that day which all it has been entire, it's been sacked off by the Calcutta High Court, it came before the Supreme Court. The three judges which was hearing this matter.
Calcutta matter, that teachers
Teachers, that OMR and all
it's
those.
so intermingled thing.
That's why I'm
Good
saying,
from the bad you cannot.
then whoever.
But here, thanks to
Nysa,
you,
I was
thanks
hearing it.
to you, the petitioners, now the persons who would be appointed in the school, there is some semblance of merit.
But
Because the persons who were there, 22 carats, now it was 22 carats or 18 carats. Now by your endeavor, you have taken it up to 24 carats. It's pure now.
But-
999.
but-
0.99 will still be there.
But by the operation successful, but patient dead. That's what, my lord, what has happened? I made all those endeavors to bring to the court that this is what the selection committee, how they have done. My lord, replacing or 12 also they made a mistake.
Two.
I mean, now
gone.
today, your lordship said and found that two of your candidates also doesn't qualify. Oh, how they have, my
I
lord,
told you the other day,
my lord,
Mr.
as a-
Mohanto is too secretive.
So,
If these materials
Canada,
were there
my
before the
lord,
court 1 year before,
IAC, how the APS.
Mr. Dotto and Mr. Bothakur need not have taken the trouble.
How they are callous about it, my lord? These are serious cases, my lord. Your lordship sitting there found that two of your candidates also have.
No,
They
that is
could-
disclosed by them.
No, my lord, whatever may be, that they have not brought notice to the court. This is what I am saying, my lord.
Maybe he did not want to give you a gun and then shoot him back.
But I have qualifying marks, my lord. One should know what is the qualifying marks. That is true, my lord.
That
will disclose after the competition,
there is a Supreme Court judgment. of
Yes.
this.
There is judgment also,
Okay, what was that?
But the process has to be completed.
RTI thing will be given. Huh?
No, there are another case, 2024.
I didn't get you.
Yes.
Name I didn't get. Then I will. That RTI can be made only after
Competition.
completion of this election.
That is followed by UPSC also.
UPSC. Okay, Mr. Das,
Yes,
anything
it's
more?
okay, fine, my lord. But your lordship,
I'll not trouble you. You can carry on with your other briefs.
I am supposed to leave for
So,
some outstation. Yes, sir.
My lord.
India or
No,
For
here,
big fish.
my lord, walking
big
2
fish.
hours.
For
big
big
fish?
fish.
Big fish.
My lord.
Now I can't say anything on that.
My present is my.
We will record it. Sir. But
I can, your lordship.
yeah, please take it. Mr. Monta, you also can go, Mr. Sharma will.
Hello.
Heard Mr. D. Das, Learning Council for the petitioner. Mr. Bhattakur, Mr. Doctor, who is assisting you? You are the doctor, Mr. Doctor.
Yes, sir.
Just write down the respondents you are appearing for. I'm also Mr. Bhattakur. Heard Mr. D. Das, Learning Council for the D. Das, Learning Senior Council for the petitioner, for the Senior Council, assisted by Mr.
K. Mohammed.
K. Mohammed, Learned Councils appearing for the petitioners. Also heard Mr. Mr. K. Gogoi, learned Standing Council, Higher Education Department, Higher Technical Education Department, Higher Education Department, for respondents number 1 and 2. Heard Mr. T.J. Monto, assisted by Miss Senior Advocate, assisted by Miss S.
P. Sharma.
P. Sharma, Learned Council, representing the Assam Public Service Commission, respondent number 3. Also heard Mr. S. Dotto, Learned Senior Council, assisted by DJ Medi, Learned Council, representing the respondents number -22. Also heard Mr. S. Bhattakur, Learned Council, representing the respondents. Full stop. As consented to by the Learned Council for the parties, the present with petition is taken up for final consideration and disposal. Full stop. The facts as a requisite for consideration of the issues arising in the present proceedings is noticed herein briefly. Full stop. The Assam Public Service Commission, on a requisition being placed before it by the concerned department, proceeded to issue an advertisement dated 25/5/2017, inviting applications amongst others for 66 posts of assistant professor, bracketed technical, in 9 different subjects in engineering college, in 9 different subjects in the various Indian engineering colleges of the state. Also, in terms, the petitioners hearing content that they being so eligible and participate in the said, have submitted their applications in pursuance to the said advertisement, and their candidates have been found to have satisfied the eligibility criteria as mandated therein, they were permitted to appear in the written examination held by the commission in the matter with effect from 7/11/2019 to 13/11/2019. So on conclusion of the said written examination, the commission, via notification dated 28/5/2020, proceeded to publish the list of candidates subject wise who had qualified for appearing in the next segment of the selection process, that is a written test on local languages of the state. Also, the name of the petitioners duly figure in the said list as published by the notification dated 28/5/2020. Also, thereafter, the petitioners hearing, along with the other candidates whose name figure in the notification dated 28/5/2020, undertook the language test on local languages of the state, which was held on 7/11/2019, 8/11/2019, and 10. Which was subsequently held. Full stop. On conclusion of the set qualifying, the set language test, which has to be noted was of a qualifying nature, the Assam Public Service Commission proceeded to publish a notification dated 6/10/2021, wherein the shortlisting the candidates for appearing in the next component of the selection process, that is the viva voce / interview segment. So, the petitioners herein, the names of the petitioners herein, however, did not figure in the said list, and accordingly, being agreed, the present proceedings were instituted before this court. Also, this court, on while issuing a notice in the matter, while an order dated 12/11/2021, noticing the grievances raised by the petitioners in the matter that there were candidates included in the list dated 6/10/2021 who did not satisfy the eligibility criteria as mandated in the said advertisement. Also, noticing the said grievance as raised by the petitioner, this court had directed the APSC authorities to verify the respective educational qualification of the candidates in respect of each department for which they have so applied, and to subject only such candidates who fulfill the eligibility criteria to the interview process. Also, in terms of the directions as passed by this court, it is seen that the APSC authorities proceeded to constitute a committee of experts in the matter, and the said committee proceeded to verify each of the credentials of each of the candidates participating, whose name who was held to be qualified to appear for the next segment, that is the viva voce segment of the selection process. Also, the said expert committee, after verifying the educational qualification of all the candidates who were shortlisted via the notification dated 6/10/2021, proceeded to recommend that 41 candidates who were so shortlisted via the said notification dated 6/10/2021 did not possess the eligibility criteria as mandated, and accordingly were held to be ineligible for being considered for the selection, considered in the recruitment process underway in pursuance to the advertisement in question. Full stop. The said material coming on record, the commission approached this court by way of filing an interlocutory application being IA-C number 2232 of 2022, praying for leave to publish the fresh list of candidates after the scrutiny as was undertaken by the said expert committee. Full stop. The said interlocutory application was disposed of by this court via an order dated 6/9/2022, wherein it was directed that the Public Service Commission shall now also verify the educational qualification of the candidates who would now replace the candidates now excluded from the list dated 6/10, notification list contained in the notification dated 6/10/2010. So, accordingly, on the basis of the scrutiny so made, the committee recommended for the inclusion of 12 candidates in lieu of the 41 candidates who were now removed from the list dated 6/10/2021. So, accordingly, the said process having been so advanced, the commission proceeded to institute IA-C number 3095/2022, giving the details of the 12 candidates who now would be included in respect of included in the list as contained in the notification dated 6/10/2021. Also, however, the petitioners raised objection with regard to 2 candidates out of the set 12 candidates now so included. And accordingly, a review was further carried out by the commission, by the expert committee, and thereafter on coming to a conclusion that actually the 2 candidates identified by the petitioner were not eligible to take part in the selection process, the number of candidates so recommended was reduced to 10. Also, the commission thereafter, the expert body as constituted in the matter, thereafter on 28/11/2022 proceeded to submit a list department-wise of candidates now found eligible to be called for the next segment, that is viva voce oblique interview. Full stop. At this stage, it is to be noted that this court had wide an order dated 18/11/2022 on the scrutiny so carried out by the expert body being brought to the notice of this court, had permitted the APSC authorities to proceed with the selection process for the assistant professor, non-technical and librarian posts, which were also advertised, while the advertisement dated 25/5/2017. However, the leave for publishing notifying the fresh list of candidates now shortlisted after the process of verification undertaken by the said expert committee was, however, not permitted to be published without further clarifications. Also, the APSC authorities, in terms of the said order dated 18/11/2022, proceeded to publish the list of assistant professors now found eligible for participating in the interview segment of the said selection process, and thereafter conducted the interview and prepared the select list of the matter. Also, the APSC authorities thereafter approached this court. Itu arus 1900
1960.
1960. Approach this court by way of an interlocutory application being ISC number 1960/2023, seeking leave to publish the final select list with regard to the posts of assistant professor, non-technical, and the post of librarian in government engineering colleges of the state, advertised, while they said advertisement dated 25/5/2017. This court, while order dated 17/2/2024, proceeded to dispose of the said interlocutory application, permitting the APSC authorities to proceed but order dated so and so. This court proceeded to grant leave to the APSC authorities to publish the final select list against the advertised post of assistant professor, bracketed non-technical, and the post of librarian as existing in the government engineering colleges and advertised by the said advertisement. So, and it is stated in the bar that the said process with regard to the posts of assistant professor, non-technical, and the post of librarian were taken to its logical conclusions, and the select list in the matter so published. However, in view of the directions as passed by this court, in view of the refusal by the, in view of the orders passed by this court wide order dated 18/11/2022. The list as now finalized by the expert committee pertaining to the posts of assistant professor technical advertised while the said advertisement could not be published, although the same was brought on record in the present proceedings. So, as the matter was placed at that stage and the present proceedings were thereafter taken up for consideration, this court had, on appreciating the contentions made by the parties, proceeded wide order dated 9/5/2024 to require the Assam Public Service Commission to place on record the instructions as sought for, instructions as to furnish information on the issues as culled out therein. Also, the said order being of relevance to the present proceeding is extracted herein below. Page 9/5/2024, A to A. So, in terms of the said directions, Ms. P. Sharma has placed the information as sought for before this court in a seal cover, and the court had perused the same. Also, Mr. T. Das Learned, Senior Counsel, appearing for the petitioners, have, by taking this court through the various process of the various, by taking this court through the irregularities as highlighted by the petitioners in the matter and the rectification process thereof as undertaken by the Assam Public Service Commission, which is contended to be an admission of the said recruitment process not being carried out in the manner that is so called for, has contended that in view of the irregularities as taking place in the matter, this court would be pleased to interfere with the selection process and direct the APSC authorities to carry out the process involved de novo. Mr. Das has fairly submitted that all the petitioners herein have not questioned the manner in which the language test was held, and they had participated in the said examination without raising any objection thereto. But Mr. Das submits that given the illegalities available in the process of selection as undertaken by the Assam Public Service Commission, the same does not inspire confidence, and therefore the process ought to be interfered by this court, and a direction a direction for carrying out the same de novo mandates to be issued in the matter. Anything more? These are basically the two submissions. Per contra, Mr. T.J. Mohanto, Learned Senior Counsel, appearing in the matter, has submitted that the allegations as highlighted with regard to the process of selection basically pertains to the educational qualification process by candidates who were shortlisted for the purpose of appearing in the interview, viva voce / interview segment of the selection process. And included in the list as published by the notification dated 6/10/2010. Mr. Mohanto submits that the exercise as carried out by the commission is a involves verification of voluminous records. And it is possible that certain candidates, although not eligible, may have been permitted to continue in the selection process and may have also been shortlisted for the purpose of interview. However, Mr. Mohanto submits that as per the practice followed by the commission, the credentials of each and every candidate is thoroughly scrutinized at every stage, and at any stage it is found that any of such candidate is not eligible to take part in the selection process, the candidature of such candidate is rejected. Full stop. Mr. Mohanto has further submitted that given the nature of allegations raised by the petitioner, the APSC authorities had constituted an expert committee constituting of 3 eminent persons having detailed knowledge of the technical subjects, as well as having experience of the requisite qualification mandated for the post of the nature as advertised by the advertisement in question, and the said committee had meticulously perused the credentials of each and every candidate shortlisted by the notification dated 6/10/2010. Mr. Monto submits that on such exercise being carried out, it was found that 41 candidates did not possess the requisite educational qualification for participating in the recruitment process against the post for which they had offered their respective candidatures, and the said 41 candidates so identified belong to the different streams of the different subjects which were against which the posts of assistant professor bracketed technical were so advertised. So, Mr. Mohanto submits that on the said 41 persons being so identified, steps were taken for their exclusion from the recruitment process, and none other 12 candidates who were now found eligible for inclusion in the who were now found eligible for being considered by in the next segment of the selection process, that is viva voce of the interview component of the same, have been so included in the set list. Mr. Mohanto has further fairly submitted that on a further scrutiny made out of the set 12 candidates, 2 were again found to be not eligible for being permitted to continue in the recruitment process, continue to be considered in the recruitment process, and accordingly they were also excluded therefrom. Mr. Mohanto has submitted that after the scrutiny oblique verification process as undertaken by the expert committee, the candidates who have now been shortlisted and who have been now shortlisted by the said expert committee, no further allegation thereon were raised by the petitioners, and accordingly it can be construed that the said candidates who have now been so shortlisted for the various posts involved, more particularly the post of assistant professor technical, have the requisite eligibility criteria. Where is that ratio? There is something, you brought it here, ratio.
Ratio part also that's in the written argument.
I've got that. Also, during the course of deliberation of the matter in the matter, comma, this court had raised the query with Mr. Monto as to why 41 candidates, as to why the 41 candidates so found ineligible to participate in the recruitment process and removed were not replaced by another set of 41 candidates, and only 10 were so incorporated. But 10 candidates were only selected for replacement of the set 41 candidates now removed from the selection process. Mr. Mohanto has submitted that the candidates are shortlisted for the viva voce component from amongst the candidates who had crossed the, who had qualified in the written examination, as well as passed clear, as well as achieved the qualifying marks in the language test in the ratio of, where is that circular? I found it somewhere.
Lordship.
No, it's here. Where is it? It's available on record.
an objection
Huh?
on,
My lord, we have filed an objection in I 3095, sir. We have
3095. Hey, that is it. 3095. Ah,
stage number 13.
309. Yes. Ah. A query was raised. So, sir, Mr. Monta has referred to a notification dated 4/10/2021 issued by the APSC authorities, wherein the ratio in which candidates would be shortlisted for the interview segment of the said recruitment process is mentioned. So, in terms of the said notification for categories where there are 1 to 5 posts, where 1 to 5 posts have been advertised, candidates 6 times the number would be called for the interview. For posts with for posts as for 6 to 10 numbers of posts as advertised for categories, 5 times the number of posts would be called, and for 11 and above, 4 times the number of candidates would be so called in the interview component. Mr. Mohanto, by referring to a chart brought on record by way of a written argument in IAC, submitted in IAC number 1960/2023 in a present repetition number in WPC number so and so, has contended that the ratio in accordance with the said prescription has already been met, and even after removal of the candidates, it was not mandated for incorporation of more candidates in many of the categories as available, in as much as the ratio was already maintained. Full stop. Having also, Mr. Monto submits that the APSC authorities be now permitted to proceed to publish the list as now shortlisted by the expert list of candidates now shortlisted subject wise against the post of assistant professor Technical advertised wide the advertisement dated so and so. And thereafter proceed to take the selection process to its logical conclusion. Mr. S. Datta, Learned Senior Counsel, and Mr. S. Bhattakur, Learned Counsel, appearing for the private respondents while adopting the arguments raised by Mr. Mohanto, T.J. Mohanto, Senior Advocate in the matter, has contended that the recruitment process was initiated in the year 2017, to be more particular on 25/5/2017, and the same is still not taken to its logical conclusion because of the proceedings as initiated in the matter by the petitioners. Full stop. It is contended that there is no allegation against the respondents as represented by them in the present matter, and accordingly, for the fact that certain candidates were found to be ineligible to participate in the said selection process, and the directions passed by this court, their rights to have their respective cases considered for recruitment against the post to which they have applied, has been kept in abeyance, post of which has severely affected their rights, and including have affected their rights, and accordingly it is submitted that this court would be pleased, in view of the materials coming on record, to dismiss the petition and permit the Assam Public Service Commission to take the recruitment process to its logical conclusion. Anything more, Mr. This will do. What I want, anything more? Oh, sorry. Yeah, I'm coming to that. Mr. Gogoi, Learned Counsel for the petitioner, appearing for the Higher Education Department, has submitted that in view of the materials now coming on record, it is abundantly clear that the petitioners have not made out a prima facie case in the matter requiring the interference of this court with the recruitment process in issue in the present proceedings. Mr. Gogoi has submitted that the delay as occasioning in the affecting the appointments of the against the vacant posts of assistant professor technical, now advertised wide the said advertisement dated so and so, is severely adversely affecting the functioning of the government engineering colleges, and the same, if permitted to continue, would adversely affects the would affect the students studying therein, full stop, which would not be in larger public interest, and accordingly, he also requires this court to permit the Assam Public Service Commission to take the process of recruitment involved to its logical conclusion at the earliest, and facilitate appointment of selected persons against the post in question. Anything more? I have heard the Learned Counsel for the parties and also peruse the materials on record. Full stop. Although the objections as raised by the petitioners in the matter had led to a scrutiny by the APSC authorities, wherein certain candidates were found to be not eligible to participate in the certain candidates who were admittedly not eligible to participate in the selection process were permitted to continue to be involved, continue to be considered in the selection process, the endeavor as made by the petitioners in highlighting the said aspect of the matter before this court, and the directions of this court to the APSC authorities to carry out a detailed review in the matter, it is found that the candidates not so eligible have now been taken out of the process of, taken out of the process involved with regard to the recruitment process, recruitment in question, and the petitioners after the shortlisted candidates was no, wait, full stop. It is found that the APSC authorities have brought on record the shortlisted candidates, the list of candidates shortlisted by the expert committee after scrutiny of the educational qualifications of all the candidates included in the in the list as published by the notification dated 6/10/2010, and it is seen that there is no further allegation brought on record by the petitioners in this connection. Full stop. In that view of the matter, the list now available on records after list of shortlisted candidates now available on record as prepared by the expert committee in the matter has to be reckoned to be one or consisting of persons who fulfill the educational qualifications as mandated in the advertisement for the post they have so applied for individually. Full stop. At this stage, it is also to be noted that Mr. Das had fairly submitted that the petitioners have got no grievance with regard to the manner in which the language test on local languages of the test of the state were so held by the Assam Public Service Commission, and the same, in as much as the petitioners had participated in the set component of the selection process without any objection. Mr. Das has further submitted that the materials public information as now placed on record by the APSM. The Learned Council for the parties have submitted that the materials as now placed on record by the APSC pertaining to the performance of the petitioners in the recruitment process be perused by this court and basing on the revelations as would be available therefrom to pass appropriate orders in the matter. Mr. Mohanto, Learned Senior Counsel, appearing for the Assam Public Service Commission, has requested this court not to disclose the cutoff marks and or the marks scored by the petitioners at this stage, inasmuch as the said revelation can only be made after the selection process is taken to its logical conclusion. First up, the same was also supported by the other learned counsels appearing in the matter. First up, accepting the request as made by the petitioner, this court perused the materials as placed on record by Ms. P. Sharma, Learned Counsel, appearing on behalf of the petitioners, on behalf of the Assam Public Service Commission. First up, on examination of the materials as placed before this court, it is seen that the petitioners number 1, 3, 4, 6, 8, 12, 16, 18, and 19, although had cleared, although were shortlisted in the in the list as contained in the notification dated 28/5/2020 and were eligible for appearing in the language test on local languages of Assam, the said petitioners had not qualified in the said component of the selection process. So at this stage, it is to be noted that the Assam Public Service Commission had, before the said examination was so conducted, determined determined that a candidate to qualify in the said component of the selection process must have secured 25 marks therein. Also, it is found from the materials as placed on record that none of the above named candidates had secured 25 or more marks in the said component of the selection process, and accordingly, there exists no further requirement of this court to consider their cases. Also, as regards the remaining 10 petitioners who had qualified in the language test on local languages of the state, this court has examined the materials placed on record and has found that the petitioners involved had applied against different posts as advertised by the advertisement dated so and so. More particularly, the posts as posts of assistant professor technical. Also, on a careful scrutiny of the materials as placed on record, it is found that the petitioners number 2, 5, 7, 9, 10, 11, 14, and 15, although had qualified in the said language test, but in the written examination, they had, given the application of the ratio as mentioned here in above, not achieved the cutoff marks requisite for being included in the list of candidates now found eligible for their respective subjects eligible for inclusion in the list as prepared against their respective subjects for calling them for the viva voce of this interview component of the selection process. So the said candidates not having achieved the requisite cutoff marks, this court is not in a position to direct the APSC authorities to continue to consider them in the said selection process, and accordingly, it has to be held basing on the materials as placed on record that the said petitioners also do not have any vested right to demand to continue in the said recruitment process. Also, as far as the remaining 2 petitioners are concerned, that is the petitioners number 13 and 17, it is found that the APSC authorities in their respect had come to a conclusion that the petitioners, the qualification as possessed by the petitioners do not meet the requirement with regard to qualification as prescribed against the post for which they had so applied in pursuance to the advertisement dated so and so. And accordingly, it was held by the APSC authorities that they are ineligible to be considered for recruitment against the post for which they had so applied. So, in that view of the matter, the said petitioners, that is the petitioners number 13 and 17 are also not eligible for being considered in the said recruitment process. At this stage, it is to be noted that this court, while making the scrutiny, had also taken note of the fact that amongst the petitioners, there are petitioners who had applied for more than one post, and the scrutiny as carried out by this court and the examination as carried out by this court was in relation to all the posts so applied for by the petitioners so concerned. This court has also, in respect of the female petitioners, considered whether they had achieved the cutoff marks as preferred in their respective categories for female categories, for female candidates, and this court found that the petitioners with the marks as female petitioners with the marks as involved in the present proceedings with the marks as scored by them in the written examination did not achieve the set cutoff, and accordingly they were not found eligible for being included in the list for being called for the viva voce oblique interview segment of the selection process. Also, in view of the above conclusions as reached by this court, it is found that the petitioners have not been able to, in view of the above conclusions reached by this court reached herein above. In view of the conclusions reached herein above, this court is of the considered view that the stalemate as continuing with regard to the recruitment process against the post of assistant professor technical did not be permitted to be continued any further, and the petitioners having not brought on record any further material to justify existence of any further illegality in the said selection process, this court passes the following directions. 1. The APSC authorities would now proceed to publish the list of qualified candidates as shortlisted by the expert committee in pursuance to the directions passed in the present proceedings by this court earlier, and thereafter proceed with the matter and hold the interview viva voce segment in accordance with the procedure mandated in the matter. So, on conclusion of the said component of the selection process, the APSC authorities shall duly publish the select list and recommend the names of candidates now found eligible for appointment against the posts in question to the government for further necessary action in the matter. So, this above exercise shall now be initiated and concluded within a period of, Doctor, how much? 1 month, 2 months?
1 month.
1 month, within a period of 30 days from the date of receipt of a certified copy of this order. Also, before parting with the records of the case, this court would like to observe that the petitioners have not been granted access to the marks scored by them in the selection process, and also the petitioners were not permitted to raise issues pertaining the two petitioners who were found to be ineligible to participate in the selection process on account of the educational qualification possessed by them were not permitted to raise that issue in the present proceedings, liberty is reserved with the petitioners to raise individual issues after the selection process is complete and the information oblique documents pertaining to their performance oblique qualification are provided to them by the commission. Anything more?
It will be 2 months. I have taken
2 months. 2 months. Mr. Doctor, now you can.
Much of
Thank you. With the above observation direction, the petition stands disposed. Anything more?
Kindly that may be fixed
Huh?
for other 2 cases.
Huh?
Other 2 cases, Lordship.
Other 2 cases we have said 2 weeks. We have said 2 weeks, Krishna.
Lordship.
But
Segregate.
tomorrow Kali Parivana. Order 2. I'm sorry, if we cannot type out, you will have the order Monday or Tuesday from Arunachal. I'll have it uploaded. Don't worry. But give me 2-3 days time. Yes.
My,
Yeah.
in line of your lordships of item 22 is concerned, lordship. Can it be taken, my lord, next week or?
Whenever it's not a part of matter.
Not part of.
Item number 22
After 2
on the
weeks,
prayer made by Mr. B.J. Ghosh, learned counsel appearing for the petitioner, list this matter again
After 2 weeks.
after 2 weeks on a date to be fixed by the registrar. Anything more? Yes,
My
Mr.
name may be.
Mr. I. Alam, learned counsel for the learned standing counsel, NCT is present. I'll make slight modifications here and there, but the issue would be that only.
Item 12.
My lord, still they are not.
Huh?
Still they are not represented. On last occasion also they were. No, no, last occasion.
None
they are-
appears for the petitioner on call. Even on, none appears for the petitioner even on second call. So accordingly, the petition stands dismissed. However, they were dismissed for non-prosecution. Nothing is there. What they will do?
My lord.
I don't want to find, Mr. P. Soike and Mr. U. Sharma, learned, government advocate and standing counsel, secondary education department are present.
Item 19.
I apologize for the inconvenience, my lord.
The lordship had desired an affidavit, and I placed that on record, my lord.
When?
It was filed on my on 8/5/2024. Now, if your lordship kindly takes up that affidavit,
But problem is, I'll not be here from next week.
and these days your lordship is having double duty, my lord.
No, that is nothing. Had I kept it parted, no, no?
Some deliberation will be required.
Mr. A.K. Borwa, learned counsel for the petitioner submits that an additional affidavit has been brought on record. You want to file a counter to this?
He already filed, my lord. Already filed.
Filed on 14/5, no?
He had filed, my lord, on 14/5, my lord.
Has brought on record an additional affidavit on behalf of the (14/5) you have filed.
Look, my lord, I have filed on 8/5, my lord. He has filed on.
You are
14/5.
for the private response.
I'm for the private response.
I am for the repetition, my lord, and the affidavit file already on record.
Has filed an additional affidavit
I have filed an additional affidavit. He has filed a
on behalf
counter.
of the respondent number
6, my lord.
6,
6.
and the petitioner has also filed a rejoinder thereto. Also, in view of the matter above, registry to list this case for admission hearing on when?
Whenever your lordship.
No, you tell me. I'm here 2 weeks, I'm not here. That's why you give me a date on between that. If it remains back, I come back, it comes to me, I'll take it up.
Or your,
28 to 2021.
Obliged. Deeply obliged, my lord.
This will have to go in some.
My lord. Obliged. Deeply obliged.
Supplementary list for admission, item 23.
My lord, my lord,
I will also come along with that.
my lord, because this I is for my lord, today is the I are my lord listed.
I is there for stay vacation, my lord.
I is for vacation
together.
matter.
Together it will come, my lord.
The full stop. Third day, I am in
Madam, can we
173,420.
My lord, because this I have been listed, my lord, that he has filed the I am way back. And the matter was part hard, my lord. It matter was part hard, my lord.
It was not parted.
Actually, my lord, his phone is part hard. Your lordship.
Part hard, my lord. It's a part hard matter.
Full stop. The Upamalingna, this matter will not be treated henceforth as parted matter. So I am a ligna. Heard the learned counsel for the parties. The issue, full stop, the matter would require a detailed examination, which as agreed to by the parties would now be made in the connected petition, that is WPC number 194/2024. Done with?
Obliged.
Now this is of no use. The consideration will be in the writ petition. Let it be, let it remain.
I is not closed.
It's not closed.
That much.
You may have a fear that he may press, that's not there. No.
It's not there. Ultimately.
Why
final-
this whole thing has to be disposed. If
Whole-
I have to take up, I will have done it. No problem.
Obliged. Deeply obliged.
Item 23.
Obliged.
Ship sails in lakes.
A matter of sinning.
Lordship, 5 minutes time may be given, Lordship.
I was listening. Where is Mr. Das?
He's coming, Lordship, otherwise we have done our part, Lord.
Kind of. Hey. Two for. Yes.
First of all, madam, I would like to point out SARS was reply, madam.
Hmm.
SARS sheet is page number 60 of the writ petition.
Hmm.
SARS number 1 is failed to conduct annual athletic meet for the academic session 2020-23.
Hmm.
In this regard, my lord, in this regard, I would like to point out some his statement, my lord, regarding this SARS number 1, my lord. Here the question is that are you in charge of the annual athletic meet 2020-23? Yes. When did you come to know that you have been made in charge of the annual athletic meet 2020-23 at the moment when the annual calendar was published? Then, my lord. After my lord, then our next question is I am just submitting only the relevant question, not the other question, my lord.
Hmm.
After 22nd of the, why didn't you approach the authority to conduct the annual athletic meet on the later date?
Hmm.
I was not informed. I assumed that annual training camp was conducted, so it will be informed officially to me.
Yeah,
Then
this is question number.
question number 11, madam.
Hmm. Hmm.
Then, madam. Is there any meeting held with all staff for reschedule of the event? I am not aware. I cannot recall now. His answer is I get.
Any question with regard to he being informed by Kushua?
My lord, that is. A.K. Kuswat was called by the Board of Witness.
No. To the petitioner.
To the petitioner, my lord. That is, my lord, cross question by the search teacher to the A.K. Kuswat.
No.
Who do?
You are reading the questions put to the charge officer.
Yes, my lord.
Therein,
There,
any
my lord.
question put that whether he was informed by
By the
Kushua?
by the Kuswat.
Hmm.
No, that is not here, my lord. My lord, now may I read the
Just a
submissions?
minute. Hmm.
My lord, that now the
What
statement.
do you want to submit about charge number 1?
Charge number 1, I want to submit that, my lord, he was the in charge of the annual athletic meet. He did not conduct for whole session, my lord. even not the reschedule, not the actual date, not the post date. He did not even contact. That has been proved by that, my lord. That has been proved, and he also submitted his representation of the finding, my lord. That is page number. That is page number 112, my lord. Last part, my lord. Of the repetition, page number 112, my lord. I submit my sincere apology for having failed to conduct the annual athletic meet for the academic session 2022-23. At the same time, I would like to mention that I conducted the annual athletic meet for the academic session 23-20 for the next month, from 28 August 2023 to 30 August 2000, for which I was verbally appreciated by CDR Sohan, officiating principal. That means he did not conduct the annual athletic meet for the session 2022-23, my lord. That is his submission, my lord.
No, that is not the charge.
The charge is there, my lord. Kindly see the charge. He failed to conduct the annual athletic meet. That is page number 60, my lord.
Read it with that statement of
Fail-
petition.
Failed to, charge number 1, my lord.
I got it.
Failed to,
Conduct the annual for the academic session 22-23.
yes, my lord.
Now come to the statement of misconduct, page 61.
Yes, my lord.
Here it was said that annual athletic meet
for
was
the session-
rescheduled due to so and so, and you were informed to conduct the event at a later date.
Uh-huh.
You have failed to conduct the competition.
Yes,
That is
ma'am.
the charge.
That is the charge.
That
my-
you did it, but the date was given
Yes, my
on
lord.
that date. Now you come to the inquiry.
That inquiry, my lord, that question was put by, put to that AK Kushwaha, my lord. His question is that
No, I'm not on that. The findings of the inquiry.
findings of the inquiry. That is in
102. 102.
page number 103. Start from 102, my lord. Our teacher has accepted that he did not conduct the annual athletic meet for the academic session 22-23. The board also found
This
that,
is what?
yes,
This is the allegation.
yes, my
That
lord.
he did not hold it
Yes,
after the rescheduled dates were informed to him by Mr. A.K. Kushwaha.
yes,
Okay.
yes, my lord.
Now, so Kushwaha is the main man.
Yes, my lord.
Was he put any question in the inquiry on this connection? In this
Yeah.
connection?
Here, my lord. Question number 30, my lord. After approval of principal, sir, for the rescheduling of the event, did you inform to all inserts or not? He is one of the inserts, my lord. Yes, 100% information was given.
I'm not on that. I'm whether this question was put to the petitioner.
A petitioner. Was there any meeting held with all the staff for rescheduling on the event? I am not aware. I cannot recall now.
Question number?
Question number 20. I am not saying there was a no meeting conducted. In the search sheet number 4, annual election for the session 22-23 was rescheduled due to ATC and IPSA. I was informed to conduct the event. At the letter said I have failed to conduct the event without my approach to the authority. The event has been rescheduled. If there is any written circular regarding this, please mention. There is no written circular, madam. But in this his representation, he himself stated that, my lord. May I read his line, my lord? I conducted the annual athletic meet for the next session 23-24 from 28 August 23 to 30 August, for which I was verbally appreciated. Next year also he was verbally appreciated, my lord.
Okay, anything more on first article charge?
The first one was charges that failed to conduct that for 2022-23, my lord.
Okay.
That is his own submission that he failed to conduct that 22-23, my lord.
Anything more?
No, my lord. That is regarding
Ms. A. Gain, Learned Council, for the appearing for the respondent school has submitted with regard to charge number 1, that the said charge was admitted by the applicant, by the petitioner. Full stop. In this connection, Ms. Gain refers to page number 112, no?
yes, my lord.
to the representation as submitted by the petitioner against the finding of the inquiry committee, wherein he has submitted his sincere apology for having failed to conduct the annual athletic meet for academic session 22-23, and wherein he has submitted that he has contended that he had held the annual athletic meet for the academic session 23-24, for which he was verbally appreciated by the officiating principal. Also, एक bracket में करना, bracket में box. On being queried by this court as to whether the petitioner in the course of inquiry was confronted with any question pertaining to the allegation as contained in the statement of imputation that he had failed to conduct the event, even in spite of being informed about the rescheduled date. Ms. Gayan fairly submits that the questions as put to the petitioner hearing does not reflect the said position. Bracket close. Then, what is Kushova's statement? Ms. Gayan, in support of the said fact, refers to the statement of Mr. A.K.
Kuswa. Kuswa, after approving the principal sir for rescheduling of the event, did you inform
Kushova. The statements of Mr. A.K. Kushova,
in question number 30, my lord?
in question number 30,
Yes, ma'am, 30.
wherein he had deposed that after the discussion, after the rescheduling of the date of the said annual athletic meet by the principal, the same rescheduling were in a meeting.
Information was given.
When rescheduling, just read the whole thing.
My lord, after approval of the principal sir for rescheduling of the event, my lord.
Submits that after wherein he has deposed that after the approval of the principal to the rescheduled dates of the annual general meeting, annual general athletic meet, the same was communicated to the petitioner hearing, was duly communicated to the petitioner hearing. Now,
Now, my lord, his signature is also there. In his presence, question was put, my lord.
what is this cross?
That is, my lord, cross. That is the that cross, my lord, that is put by a person. Cross is, my lord, cross question by the SARS teacher to the A.K. Kuswa. Can you tell me the month when you were asked to reschedule the annual athletic meet 2022-23? It was not only the annual athletic meet which was rescheduled. Principals are asked to me to prepare the plan for all the remaining events. Since M.K. Kuswa, yes, A.K. Kuswa. Senior master was to produce for TD to IIT Gandhinagar. The meeting was related to NDA for class 12. After the meeting, principals had asked me to prepare the plan for remaining event of the year and asked me to show him at his office. Next question is, did the order of rescheduling was done prior to 19 December 22 or post 19 December 20? Yes, I have checked the minute, but it was before ATC conducted.
Before?
Before ATC conducted. Before I could approach about my event, it was already rescheduled. If on that is not the thief question. These are the cross question given put by the SARS teacher, sir.
There is nothing. Is there any document that was said to be circulated?
No, sir.
Ms. Dan, bracket mein, has also fairly submitted that no order or document pertaining to the said rescheduling is available on record, and the same has also not been stated by Mr. Kushua to have been furnished to the petitioner hearing. Okay, then.
And my lord, that is.
Bracket no, which is,
Now, my lord, next, SARS, my lord. You have failed to implement the Atal Tinkering Lab in the reasonable time frame, my lord. My lord, here, my lord, board was constituted on 2/10/2022. That he has already submitted, my lord. And it was reconstituted on 10/11/2022.
Constituted on?
2/10/2022. And it was again reconstituted on 10/11/2022. And according to him, my lord, the reasonable time to set that that is 2-3 months, my lord. That is his statement, my lord. And from it appears from his representation, my lord, that is page number 100 and yes, ma'am, page number 114.
Hmm.
I, Gautam Dekha, is extremely sorry for delay of setting up Atal Tinkering Laboratory in Sainik School, Guwahati. The delay was not from my side, that is his statement. I kept on working passionately toward the completion of the assigning tasks as it is my area of interest. I am sure that Atal Tinkering Laboratory will soon become function in the Sainik School, Guwahati. But this representation was of dated 12 October 2023, my lord. And that the board was constituted on 2/10/2023 and 10/11/2022. Madam. After 11 months of lapse, he could not could not complete that they could not say that
What are the materials? The board?
materials, my lord. That is his own submission, my lord. Then materials, my lord.
Hmm.
Physics. My lord, that is a document, my lord. It is, my lord, letter dated 17/10/2022. A board consisting with the following members will assemble with effect from 15 October 2022 for set up the Atal Tinkering Lab. The board will carrying out the all the related works for the same. Presiding officer SKSM to the members Gautam Dekha, SM Roman. The board will submit the completion.
This is the first constitution.
First constitution, my lord. Then, my lord, this is the second constitution, page 87, my lord. Of the record, my lord.
Now, who produced these documents before the board of inquiry?
That produced by that authority, my lord. Yes, my lord, produced by the authority.
Directly before the board.
Yes, my lord.
Now, you were referring to that questions with regard to the charge number 1.
Yes, my lord.
Who were asking those questions? Who
Which
asked
one?
that questions?
Which one?
The questions to Shova and the petitioner. Who was asking that questions?
That was, my lord.
Question number 11, question number
Question
20.
number 11, my lord, put by class number 1. Yes, my lord. Question number 1 put by put to the SARS teacher by that inquiry
Inquiry officer.
Yes, my lord.
There is no provision for a presenting officer in your proceedings.
There is no provision, my lord.
Where do I get how this board is to be constituted? Where do I get?
There is an
You have not placed anything on
there
run.
is a rule book, my
In
lord.
the rule, it's there.
Yes.
Yes, rule is there, my lord.
Where?
Army rule book is there. Army Sonic School Society rule.
Society rule 215,
Yes, my lord.
right?
Yes, my lord.
215, Mr.
Yes, my lord. I got a copy. Perhaps, my lord, I have given one copy in the records.
Discipline rule, something is there of that
Yes.
sort.
No, there is a Sonic School Society rule, my lord. There
Rule?
is a I'll produce that documents, my lord, regarding this, my lord, regarding constitution of the inquiry authority.
How the inquiry should.
Yes, my lord, I'll produce, my lord.
Okay,
Yes,
proceed.
I'll produce it, my lord. How did it constitute, my lord?
Ms. Egan has submitted that the questions as questions to the witnesses as well as the petitioner in the inquiry was put by the inquiry officer in as much as the rules as involved in the matter. The procedure as laid down in the
Which
rules
school rule?
holding the field does not mandate appointment of a presenting officer.
My lord, regarding second search, my lord.
Just so.
Yes, my lord.
It does not lay down any rules, any procedure.
There
So,
is a,
because there is a line here,
my lord, how it consider, I'll produce that.
and you do that,
Yes, my
but
lord.
he has just on the, just
Yes,
to
ma'am.
clear the
Good.
doubt, I'm just saying.
The requirement of law is there.
The employee shall have no right to request for inquiry into his conduct by an officer other than the presiding officer of the inquiry. But members of the inquiry so constituted can be changed by the principal on representation of a representation, so and so if he feels. Employee will have no right to request for inquiry into his conduct by an officer other than the presiding officer of the inquiry. Okay, again,
Yes.
Madam, you show me that.
Yes, ma'am, I'll show you. Good. That is,
Then-
yes, my lord. I have done fraud and but. as due to
Okay, fine,
submit-
you give it to me, that
Yes,
copy you give it to me.
yes, ma'am.
Then,
Then
charge number 2.
charge number 2, my lord, document is page number 86 of the record, that is regarding the first constitution of the
Constitution
board.
board.
Then second constitution, he is the presiding officer as per the second board, my lord, that is page number 87. And my lord, from that is constitution 10 November 2022, and he himself admitted in his representation that till till the date of his submission of his representation, he did not conduct did not, that is page number. That is page number 115, my lord. I take moral responsibility. Oh, no, sorry, my lord, not 115, my lord.
114.
114, yes, my lord. I am sure that Atal Tinkering Laboratory will soon become functional. That means till that day, my lord, that they did not function, my lord.
Okay. Ms. Gain, with regard to the article of charge number 2 has submitted that the charge pertains to the failure on the part of the petitioner to implement the Atal Tinkering Lab in a reasonable time frame. Ms. Gain, by taking me through the findings as recorded against the said charge in the inquiry report, has submitted that the board on examination of the matter had found that the said implementation could have occasion within a period of 2 to 3 months. And it is contended by Ms. Diane that the board with the petitioner as in its chair was reconstituted on 10/11/2022. And in spite of the said position, even after the inquiry on the date when the petitioner had submitted his representation against the findings of the inquiry committee, that is on 12/10/2023, the said lab, he had expressed his regret for the delay in setting up of the said lab in this school. However, he has also said that the delay was not on his account. Also, accordingly, Ms. Kayan says, given the charge as framed against the petitioner in the memo dated 21/7/2023, read with the statement of imputation, comma, it has to be held on the basis of the material considered by the inquiry committee that the charge is proved. Next.
Next, my lord, charge number 3, my lord. Number 3 is my lord.
Being in charge of IH obstacle competition, you failed to conduct the event in a befitting manner.
Yes, my lord. Yeah, my lord, page 105 is findings of the inquiry committee, my lord. The event was initially planned to be conducted on 25th November as per the terms of calendar. However, in one academic meeting, the SARS teacher had approached the authority to conduct the event on 23 November instead of 25 November 22 by stating the reason of non-ability of class 9 and 22nd due to their NDA tour. The SARS teacher failed to conduct a meeting before publishing the general instruction and left the school on 16 November 22 without informing Mr. Sanjoy Deka about a meeting which should have been conducted before finalizing and publishing the G1 in part G1 in part 1. In his reply of the search sheet, he has mentioned about the shortage of manpower as the main reason of poor conduct and indiscipline of the cadet during the event. However, after comparing with the attendance register 23 November 23 and general instruction of last obstacle competition with 18-19 board has found that there was no shortage of manpower. See data, my lord. Additionally, SARS teacher failed to approach or apprise authority about the shortage of teacher and continued with the conduct of the event. Therefore, his claim of shortage of manpower teacher has been found invalid by the board.
Come to the next one.
After cross-examination, Mr. P.K. Odhikari and Mr. S.M. Rahman and Sanjay, it was found the event was not conducted in befitting manner. Please refer
Now refer to your records.
Yes,
Who cross-examined?
Yes, ma'am. Yes, ma'am, I am coming after reading. Board also found that P.K. Odhikari and other senior housemaster were not assigned any duties during the conduct of the event. They were not assigned the duties to look after their respective houses during the event. As per the board understanding, if housemaster are given no duties, then there should have been no case of indiscipline by the cadet. However, the incident of indiscipline took place. Therefore, board also found out the housemaster of the erstwhile senior house should also be held accountable for poor conduct of event along with the search teacher as he failed to conduct the briefing to the housemaster and cadet before the event. IH obstacle is a major event which involves all the teaching staff, administrative and general employee of the school. As per the school working ethic, coordination is always conducted before actual conduct to inform all involved personnel about their role, responsibility and roles and of the event. However, SARS teacher failed to conduct a coordination meeting before the event, which led into finally cancellation of the event. The SARS teacher has accepted his failure in conducting the coordination meeting. Please refer attached statement. The SARS teacher has also accepted his failure as the SARS of the event, as an in charge of the event. Board found that event was not conducted in a befitting manner. Yes, my lord. SARS number 3, my lord. Here, my lord, question number 7. Put to the SARS officers, SARS teachers, man. Have you conducted coordination meeting? No, sir. Then, my lord, question number 9. As a teacher of in-charge, have you not done? I am not professional. As a teachers in charge, have you not? No, sorry, there is something. Did you conduct the briefing to the cadet before conducting the event? Regarding the briefing, PTI does it before starting of event. That is his duty, but he said that PTI did that. As a teacher in charge, have you not done? I am not professional. Then, my lord, question number 10. As a teacher in charge, you must have done the briefing. PTI explain everything. PTI is technically sound. Then, my lord, question number 97. Question number. How many days before meeting had to be conducted? 7 days before. Then, my lord, Nehal, why you don't publish the general instruction before leaving the school? I left the school campus on 16 November 22 till 15 November 22. Each and every teachers are busy covering the syllabus. Be specific to answer why you don't publish the general instruction. I was busy in covering the syllabus for class 9 and 10 physics till 15 November 2022. Then question number 18, my lord. Did the meeting conducted? No. That briefing meeting did not conduct, my lord. That is my submission, my lord. Then how many, that is then 7 days before he had to conduct that meeting, but that is it. Then question number 23. Did you face any kind of problem while conducting the event? I had faced problems, severe shortage of manpower in distributing the duties. So I had to make some last minute changes. Then, my lord, question number 27. Did all the teachers were cooperative while conducting the event? Yes, sir. I have not seen any lacuna or unprofessional conduct by the teacher. Then, my lord, question number 40, my lord. There was no shortage of manpower as per the attendance of the employee of the sufficient persons were there. Science teacher had there been teachers in place of the general employee and administrative staff, and incident would not happen because cadets are very fearful to their teachers, and they admire that in respect of their teacher. Had there been more number of teachers, or if I could put 6 teachers on duty, the cadet probably would not have dared to speak ill with their counterpart.
Okay, now just clarify this page 105 clause 5. That cross-examination of P.K. Odigari, S.M. Rahman,
Yes,
and Sanjay Lekha. Who had done that cross-examination? Petitioner.
yes, my lord.
No.
P.K. Odigari, Sanjay Lekha, and S.M. Rahman, my lord. That was done by inquiry officer, my lord.
Okay. Anything more?
114 is the staff attendance register, my lord. That his allegation was that there is shortage of manpower, my
How
lord.
many staff were there?
There, my lord, all total 20
Teachers, how many were there?
teachers, my lord. Yes, my lord, teachers 20, 21, 22, 23, 24, 25, 26, 27, 20, 29.
Ms. Agan, with regard to the charge number 3, has submitted that the said charge pertains to the failure of the petitioner as a teacher in charge in conducting the IH obstacle competition in a befitting manner. Also, in this connection, Ms. Bhaiya, by referring to the findings of the board with regard to the said charge has submitted that the said findings clearly bring to the forefront the failure on the part of the petitioner in active coordinate to have an active coordination in the matter with the other teachers, and also not convening, and from the records she has demonstrated that the petitioner has not convened any meeting for the purpose of smooth conduct of the said competition. Ms. Diane submits that the said coordination meeting was required to be called at least 7 days prior to the date of the event, right?
Yes, my lord.
Also, Ms.
That
Diane
is his statement,
submits
my lord.
that the contentions as raised by the petitioner to justify the failure on his part to hold the said event in a befitting manner are all afterthoughts, and the material as relevant if perused in the correct perspective would bring to the forefront that the petitioner for his negligence had led to the said event not being conducted in a fair manner, and the indiscipline and the resultant indiscipline occasioning on the part of the cadets therein.
And case number 115 is representations against the findings, my lord.
Further, Ms. Binan refers to the representation of the petitioner against the inquiry report, wherein while dealing with the charge number 3, he has
In
said,
case 115D, my lord.
he
It
has
is-
said that
Mm.
he takes the moral responsibility for the indiscipline of a set of candidates as overall in charge, and has submitted his sincere apologies, which Ms. Dyer submits to be an admission of the allegation so leveled against the petition, right?
Yes, my lord.
4.
Number 4. Number 4 is my lord. Yes, number 4 is absent from duty. That is Delhi incident. my lord. Absent from duty, my lord. That in this regard, my submission is that, my lord.
Yes.
Here, my lord, 122. Lordship has already gone through that incident, what happened on that. I am not going to that. I'm just want to point out his statement, my lord, in this regard, my lord. Then, my lord, page number.
You comment.
Page number 122 of record. That is question number 49, my lord. Put to the charge teacher, my lord. Did you regularize your absence? No, during that period. According to her, no one informed him or instructed to regularize that absence. Then, my lord.
Anything else?
Yes, my lord. Did the senior master remind you verbally to regularize your leave? I cannot recall. He did not deny. He did not deny, my lord. Did senior master remind you verbally to regularize your leave for that period, my lord? He said, I can't recall. Had I have been told, I would have done.
So that goes against you again. He clarified it.
But he replied that I cannot recall.
That
but
is
he
a
did-
clarification. We'll have to take it together.
Yes, my lord, but.
So don't rely on that.
Yes,
Hmm.
my lord.
Something else, find out better material.
That is, my lord, but personally, I request you twice or thrice to regularize your leave, my lord. That is by the no, sir. This question is no, my
Okay.
answer is
That,
no.
that we'll see. We'll see.
My lord, then were you waiting for 1 month to regularize your leave? No, sir, I had discussed with you. And you gave me permission to put up an application regarding this, my lord.
Oh,
That
subsequently an application was put up.
I discussed that you have put
Yes.
up.
Application was put up subsequently.
I don't
Before
find
that, I think Sokos
He-
notice was issued. Sokos notice was before that, I think.
application, leave application दिया नहीं.
Leave application दिया नहीं. But question is that you made vice principal and you were told to put up a minute sheet with your medical issue and leave issue. Is it before putting up my application? I was so caused.
Okay. No, that is not, neither here nor there.
Yes.
Neither here nor there. Okay.
Then,
Give me some strong material so that we can blow it in his face. Directly.
that means when he had the knowledge to give the application, my
He
lord.
has
That
all
is-
full
that
knowledge.
has been informed, my lord, to him.
He has
only.
full knowledge. He wanted to come to Guwahati, so he came to Guwahati, stayed here, came back.
That's why I want.
But you will have to demonstrate that in a manner known to law.
Yes.
Ah. You
That-
know, I know, he knows.
Yes, my lord.
But law does not know, na, that's the problem. So charge number 4, what do you have to say?
That is charge number 4, my lord.
Hmm.
Here that in page number 117 of his representation,
Hmm.
had there been no TD written against my name from 16 November to 22 November in the attendance register for academic staff, I would definitely have put up to leave application to regularize my period as I have come to know that I have to regularize the period of absence 17 November.
that is
20.
it.
Therefore, I request the school authority to
Now,
regularize.
now
that.
tell me one thing.
Yes, ma'am.
Now, this is an allegation.
Yes, ma'am.
Now, you are saying that you yourself had asked him to, means your staff had asked him to submit an application
Yes, ma'am.
for regularization of that
Yes.
period. If that period you have decided to regularize, how can it be a misconduct?
But he did not give the application.
Fine, that is not the allegation. That is not the non-regularization of the period is not an allegation.
But his misconduct is that that is he was in duty of the attending.
No, no.
that,
Who
yes.
has established that that findings of the inquiry officer, inquiry report,
Yes,
what are the materials based on
Yes.
that?
findings, my lord.
Hmm.
Article. The search sir did not consult any doctor reaching New Delhi on 12 November.
Who has, what are the materials on that
Materials,
basis?
my lord. Materials.
Who are the witnesses against this? Who are the witnesses who have?
Witness, my lord. Witness is my lord.
Who are the witnesses
Yes.
with regard to charge number 4? And what are the documents you have concerned?
My lord, page number 122.
Mr. Das, did you submit all your these documents before the, once you reached 21st? Health city documents, doctors?
Yes, yes.
You have submitted those?
Yes, I submitted along with my written statement of defense,
No.
along with,
At that point of time, did you submit those documents when you returned?
yes, yes, yes,
You submitted all this?
yes, yes.
My lord, here the question is that is Mr. M.K. Singh science teacher, as a course mate at Delhi, did I ask you to visit the doctor in Delhi, but you told you would wait till evening, yes or no? I prefer to stay an open environment. My problem was suffocation. And I need fresh air. Even if I take medicine in the evening, I have to go to the same environment of closed air condition. That means he did not.
Question number?
Question number 56.
Hmm.
Then, my lord, but air conditioning is there in the aircraft or fighting as well. He can be by the flight, my lord. This answer, it is open space as compared to train.
Plane is open space compared to train.
Train, yes, my lord. Then, my lord, again, I would like to state that I requested him to regularize the leave since he was on personal leave and also asked him to visit the doctor. Did the offer support, did
Who is this
this
principal?
is Mr. M.K. Singh, my lord. He's, who was with him, my lord, in Delhi, my lord.
Okay.
Mr. D.K. Singh, my lord. Then,
Senior master.
yes, ma'am. Did he offer support for medical assistance and you refused the same? No, sir. Instead of staying with me, he preferred to stay on another place, ma'am. That is, he offered, my lord, but he did not take his. That is my.
So
lord,
this is the only statement.
Yes, that is the statement, my lord.
With regard to article of charge number 4, which pertains to the absence of the petitioner from duty on from 18 to 20, comma, the petitioner 18 to 20, and more particularly as described, as explained in the statement of imputation of misconduct at serial number T, small d, comma, Ms. Gayan submits that the petitioner had not submitted any application for regularization of his set period of absence when he admittedly had not completed the objective behind being sent on training temporary duty. Also, Ms. Gayan, from the statements as available on record in connection with the said charge of one Mr. M.K. Singh, who had accompanied the petitioner, has contended that the petitioner, in spite of being offered help, had not received the same, which demonstrates that the petitioner may had feigned such ailment in order to not proceed to attend the event for which he was sent on temporary duty. Anything more?
No, madam. That is in regard to article number 4, yes, ma'am. Then article number 5, prep report, my lord.
About bracket code. Ms. Gayan has also fairly submitted that the petitioner was asked to submit his application along with supporting medical documents for regularization of the period of such absence. However, the same could not be taken to its logical conclusion inasmuch as in the meantime, the departmental proceedings came to be instituted with the issuance of the charge sheet dated 21/7/2023. Yes, bracket close.
My lord, prep report, my lord.
Huh?
The
Prep
prep
report.
report, yes. The charges, my lord. You were detained as a duty master on 24th February. You failed to submit the prep report of the day.
What are the materials you regard to
Material
this?
his statement, my lord.
Huh? His statement.
Yes, my lord.
His statement only.
Yes.
No other witness.
Other witnesses also there.
Who is there? Who are the witnesses?
Other witness, my lord, that is Mr. M.D. Ali.
Who is he?
He is my lord M.D. Ali.
SO.
Yes, my lord. Board of Enquiry, no, my lord.
Huh?
What is that question? M.D. Ali kun asin, no?
Next second row side here.
MD Ali is, I think, that person who was there in the office to whom you handed over.
Page 193, sir.
193.
Follow লেখা আছে designation.
Designation to define also. Mr. M.D. Ali witness based on the.
SO or
Yes,
something.
Yes, something.
Right? Mr. Das?
Yes, my lord.
SO.
So designation is not here. My
Muhammad Ali, LDC.
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 Circuits are okay in my head, I suppose. Yes.
Then S. Goda, TZT maths teacher.
S. Gola.
Yes. TZT maths teacher.
Then these two witnesses.
No, and Mr. Hazarat Ali,
Hazarat Ali. Who is he?
teachers.
Teacher. And
Then Reisha Yasmin, TZT English.
how are they connected with this prep reporting?
My lord, because MD Ali come as a MD Ali, you will be asked the question related to board of candidate. Where,
Look, may I
where,
just point out, I saw the records. These are the teachers, they were also show cause. They were also given show cause notice. And statements were taken from them.
For
And-
what?
Look, with regard to that incident only.
That
Charge
boy,
number, charge
That
number, yes.
incident.
boy,
Yes.
Jason
Yes,
Boro,
ma'am, that's
Baro.
what-
Regarding this duty master allegation and prep report allegation, charge number 5, show cause notices were given to them also, these teachers.
It is reflected there.
Yes, it's
Yes,
there.
my lord, yes, notice are there,
And
my lord.
in that context, they have also said, yes, yesterday I said Millard submitted regarding Gora. His statement is also there, wherein he
Yes,
said that I failed to inform the charge officer.
No,
Almost,
this thing that they were also charged, that I did not know.
yes, 4-5 teachers, Millard, they were show
Show
cause.
cause.
They are they're connected to that house
Yes,
or the
that,
prep.
yes,
Prep, in the prep,
Oh.
for the
Prep
Prep.
means that hostel.
hostel, yes, my lord. that
Prep is the hostel.
that is the hostel.
Okay.
Here,
And
my
it was
lord,
a joint proceeding with regard to these people also in this.
I think
No.
show cause notice were given and some penalty
He
was,
was in charge of that prep, my lord, on that, for that 24th November 2022. He was that, he was the in
What
charge.
penalty was given to the others?
And that is not here, my lord. They reply to the so cause notice. That is not here, my lord. What penalty?
Okay.
My lord, here, 186.
This is from page number, how much
Page number 186
of the records?
of the records. As per Article 5, you were detailed as a duty master on 24th February 23. You failed to
page 186 now.
Huh?
It's
page
not
186 of the record.
page 186 to 192 is the statement of the charge officer with regard to charge 5.
Hmm.
Then 193 to 204. These are the statements of those witnesses, my lord, teachers.
No, she's
no.
referring
Yes,
to the-
193 to
she's referring to
204.
this part.
186, my lord,
Is
question
the-
is
the
with
petitioner.
Gautam Dekka,
Ah,
head teacher.
petitioner, yes.
Yes, my lord.
Yes, go ahead.
Question number 5, as per article number 5, you were detailed as a duty master. He was a duty master, my lord. On 24th February 2023, you failed to submit the prep report of the day. Yes, sir. Then, my lord, question number 6, my lord. Did you submit the prep report of the day? No, sir. I prepared the hard copy of the prep report, but I failed to submit the soft copy in the WhatsApp group. Then, can you repeat the answer? I could not submit the prep report on the day, though I prepared the hard copy. I could not submit the hard copy. He did not submit the hard copy and soft copy, both, my lord.
Any question with regard to duty master report?
Question, my lord. So you did not submit the hard copy or soft copy both during the duty master day. That the soft copy is to submit in the WhatsApp group and hard copy of the evening prep report not to submit by the duty master. This is the question, my lord. That means you failed to submit the soft copy and hard copy of the prep report. Do you agree or not? Yes, sir. That means he did not submit on that day, my lord. That is my
What is that? What is that with regard to?
witness.
There are two things here. Duty master report,
Duty-
because the finding is
Hmm.
failed to submit the prep report of the day and eventually the duty master report of that day.
Yes, my
What is the question put with regard to duty master report?
When did you submitted the duty master report on the day?
Hmm.
Basically, as per standing order, it has to be submitted before 9 and next day, have submitted next day before 9 AM.
He submitted.
Yes, my lord. I submitted before
And what does the other witnesses say? Anybody saying contrary?
in. Mr. MD Ali, you will be answering. Gautam Dekka was issued with a so-called notice. He has not handed over. Mr. Gautam Dekka was issued with a so-called notice. In reply, he mentioned that he has submitted the file duty master report to you, is it? He has not handed over to me. That is page number 193, my lord.
Hmm. Hmm. And what about the other witnesses?
Other is as Goda, my lord.
Hmm.
That in the month.
No, just pinpoint that.
Yes, my
Two
lord.
things. Whether that prep is something is there
Yes,
or
my lord.
with regard to that boy.
That boy, my lord, the Swan Borough.
Hmm.
There is a question, my lord, 188. Yes, my lord, question number 25, 189, page number. As a duty master, are you aware that 2 cadets were missing from the prep that day?
Hmm.
They were not missing, they had gone to the school auditorium.
Hmm.
That means in the news, my lord. How?
This is Goda.
Yes, my lord, go. That is not Goda, my lord, that is his statement.
Okay. Petition.
Yes, ma'am. How do you come to know? I was reported by the class section captain.
Hmm?
How do you came to know about the missing of that 2 cadets, that the Swan Borough and that one is the Swan Borough, my lord. In this regard, how do you come to know? It was reported by the class section captain.
Class
That means
section?
captain.
Hmm.
That means he had the information about the Swan Borough.
When it was reported, that is not there.
That is not there, but there was that as a duty master, are you aware that missing that is not there, but it was reported by the class section captain.
Okay.
That is, my lord, in regarding article number 5, my lord.
Okay.
Charge number 5.
With regard to article of charge number 5, wherein it has been alleged that the petitioner, who was the duty master on 24/2/2023, had not submitted the prep report also. The prep report, comma, must time by referring to the statement of the petitioners as adduced with regard to the said charge submits that the petitioner had admitted that the said prep report was not submitted by him. Ms. Gayan submits that the statement of the petitioner reveals that he had prepared the hard copy of the prep report, however, the same was not handed over. Ms. Gayan, by referring to the statements available on record of the other witnesses, comma, submits that the contention of the petitioner that the that the duty master report for 24/2/2023 was submitted next day prior to 8:30 a.m. is also disputed by the person to whom the petitioner had purportedly handed over. Petitioner had stated that he had purportedly handed over the said report. Full stop. Bracket Nickel. At this stage, it is to be noticed that another 5 persons were also issued with show cause notices pertaining to the incident of availability of just one borough cadet in the auditorium, which was held to be impermissible. Full stop. At this stage, the statement of Gowda be noted, comma, also the statement of Muhammad Ali at page 130 and 193. Also, 186 to 192 are the statements of the petitioner, and 193 to 204 are the statements of the witnesses. Bracket over. Anything more on this? Accordingly,
That was 189, question number 25. He had the knowledge of that person.
Ms. Gayan further submits that the unauthorized absence of the said cadet from the prep was to the knowledge of the petitioner, in as much as he was informed of the same by the
by the
class
captain.
section captain. However, it is contended by Ms. Khan that the petitioner failed to take any redressal, any measures thereon. Full stop.
Then
जो ब्रैकेट
article
में लिखा है ना वो तुम एक तो इटैलिक्स में किसी में टाइप कर दे वो मेरे लिए पीछे लिखेगा
Article 6 is out of syllabus, man. Question why you
हाँ,
told
out of
before, yes.
syllabus.
Yes, ma'am. Article 6, man, I'd like to point out his statement, manner in page number 1 to 20, manner 20 of read petition. Yes, and Article 6, page number 119 is article of search, minor, and article 120, minor, D. I, Mr. Gotambeka, would like to submit that school authority has been encouraging the student to participate in competitive exam like NSO conducted by SOF. In order to excel in this kit of examination, cadet must have extra knowledge in the subject apart from the NCERT syllabus. The school administration has also been encouraging the student to practice the question from mathematics reference book written by R.D. Sharma, and teachers are also encouraged to set the questions from the same book apart from NCERT book. I strongly believe that in question paper, there must be 2 or 3 higher order thinking skill questions for the bright student in order to give them a chance to scope more than other by dint of their extra knowledge. As a subject teacher, we should teach the topic in class catering the need of all cadets. That means he admitted that that is out of the syllabus, not in the NCERT syllabus, madam. For as a line of experience basis, he put that question, madam. For the knowledge, for better knowledge of the cadet, madam. That he submitted in his statement also, my lord. That is in 237. My lord, his statement, my lord.
How many?
237, page number of record, 237 to 239. 237 to 241, my lord.
241.
Yes, my lord.
237 to 241.
237 to 241, his statement, my lord.
And
And
who are the other witnesses in this?
Other witness, my lord.
Ali.
H. Ali, my lord.
No other witness.
No other, H. Ali.
Miss Tan, with regard to the allegations forming the basis of article of charge number 6, has relied upon the findings as recorded by the inquiry, by the Board of Inquiry in the inquiry report, and has contended that the petitioner admittedly had framed the question which was clearly out of syllabus, and the same would be evident from the contentions as raised by him against the findings of the inquiry, against the findings of the board in his representation against the findings of the inquiry committee, bracket page 112 of the petition, bracket over, wherein he has skirted the issue and had given answers which are clearly afterthoughts and a move to justify the question so framed by him, which he has left it in the said representation to the principal to decide whether the same is out of syllabus or not. Accordingly, it is contended that the said allegation as leveled against the petition against the petitioner hearing stands established from the very statements of the petitioner hearing. So with regard to the coordination, what
Yes,
do you
madam,
say?
I'm coming to that, madam. The charge is that you had failed to coordinate with other science teacher while preparing the question paper, madam. In this regard, I point out, madam, page number 237. Here, my lord, may I read?
Petitioner 236 to 240, 237 to 241. Yes.
Yes, where you, when the both teachers have been given the responsibility, what do you mean by that? Together means we both have to prepare question paper regarding. Did you had discussed the discussion before making the question paper of class 7? Yes, sir. As soon as I got the order, I discussed with Mr. H. Saleh regarding the syllabus that will be there for periodic test 3 for preparing the question paper. Basically, I taught in one section of class 7 and he taught in another section of last session. What was the syllabus decided for the PT3 exam for science? I could not recall, but chapter 7 was included. The search sheet was served to me regarding the chapter 7 question. After making the question paper, did you discuss it with Mr. H. Sali? No, because Mr. H. Sali requested me to prepare the question paper alone.
With regard to the allegation that he had not coordinated with Mr. H. Ali in preparing the set question paper, Ms. Gayan has referred to the statements of the petitioner in the inquiry and has conducted that the same reveals that he had proceeded to frame the set the question paper, set the questions in the question paper on his own motion without any reference to Mr. H. Ali. Accordingly, the charge as leveled against the petitioner stands proved. Okay,
Yes.
then
After making question paper, did you discuss it with Mr. H. Sali? No, because Mr.
I got it.
So
Let's
it
go.
is, yes. So it is not your moral responsibility to cross-check with other teachers jointly assigned for making
Let
the
us
question
not go into
paper.
morality. I
Yes,
think that is enough.
Yes, that is my lord, the statement of H. Sali, my lord.
That is enough.
Yes.
Then what?
That, my lord, the statement of H. Sali.
I got it.
Yes, my lord. That is, he was cross-examined in the, and both signature, they put their signature and Gautam Deka also put theirs in his presence. The examination has been done, my lord. Here he admitted that without discussing, without coordinating Mr. H. Sali, he put that question, my lord.
Okay.
That is my submission regarding this
Seven.
6.
Now, article of charge number
Article
7.
7, my lord.
Here you will have to meet two things. One,
Yes, my
you
lord.
had already imposed a
Yes.
penalty. And secondly, you have brought it
Additional.
back directly.
Additional, yes.
Hmm.
Regarding now, first on record, I am submitting, well, after that on merit, I will submit whether additional charge is permissible or not. So in as per the record, my lord, is page 125 of his the petition, 125. I'll start from 124, my lord. Last line, my lord. I, Mr. Gautam Deka, resumed duty on 17 August 2023, went to the office of the superintendent office around 11 hours on 19 August 2023 to collect my leave application dated 7th August 2023 in order to meet principal sir as per direction on the leave application. The officiating OS, office superintendent himself went to the principal sir office with leave application dated 7th August 23 in order to inform as well as take the permission for the meeting. The officiating OS told me that since principal sir was proceed on leave, the matter will be discussed post resume of the office by the principal sir from the leave. Principal reported back on the from the leave on 31st of August 2023. I was expecting the principal sir would call me to discuss the leave issued, but I was not called of the as a reference to 12.04. On the contrary, I was issued an office memorandum on 19 September 2023, my lord. In his leave application, he himself admitted that there was a direction to meet the principal. That is 7th of August, my lord. And principal resumed his duty on 31st of August. And that is 19th of September, my lord, that he was so-called, my lord.
Hmm.
But from 31st August 19th, that was his duty to meet the principal, my
So
lord.
if he had met the principal,
Yes,
this would not have followed.
yes, my lord, definitely, my lord. I can't say, my lord, that, my lord. But this is, my lord, this is from here, it appears that, my lord, if he made that at that point of time, my lord,
Then can we draw an inference that this, if he had met, this would not have been a charge? That's the end of the matter.
no, my lord, I can't submit that, my lord.
Don't take me to areas where you don't want me to go.
Yes.
Hmm.
And
And
that is,
one
that
other
is,
thing.
my lord, that is his admission, my lord.
That is, forget it, his thing.
And
Now tell me, what is the material? How have you brought this additional charge after this penalty?
yes, my lord, that is, my lord, in this regard, after the penalty, we had brought
Now for the same offense, he is penalized twice,
ties non-evidence.
Diasnon and this. Then I would have understood. You have done the charge 7 is a penalty you are imposing for charge 7. Then hold that period as Diasnon. Understood. But here you hold that period as Diasnon already, and then you want to make an inquiry. How is that possible? If it was the other way around, you had an argument.
Yes.
Now see, when an non-authorized absence of unauthorized absence is there, people, the authorities can come to a conclusion that, okay, the man is unauthorizedly absent. Penalty of so and so imposed. Period of unauthorized absence, Diasnon.
Yes, ma'am.
But here you have already taken a decision of Diasnon. Then come back and hold whether that period is unauthorized or not. How is that?
My lord, regarding the permissibility under law for additional charge, my lord, for that, my lord, and my lord, another point is, my lord, that alternative remedy, my lord.
No, forget alternative.
Yes,
You
ma'am.
come to this, finish up 7.
Yes, my lord, 7, my lord. 2015, 6 years.
How much long will you take? Half an hour?
Yes, my lord, not more than half an hour, that is
We'll have it tomorrow.
tomorrow, my lord.
Hmm?
Tomorrow at 2, my lord.
Hmm.
Because, my lord, I have,
With regard to, will you continue in, we'll stop in 6, you continue with 7 tomorrow.
second mean,
Mr. Das,
My lord.
yes, my lord.
is that not the procedure that if there is a period of unauthorized absence, article number 7 is unauthorized absence, basically. That has to be first determined, then Diasnon, or
Okay.
Diasnon can be given prior to that, and then that period, whether it's unauthorized or not, can be.
No, both the things are wrong, my lord. If
I'm
you
not
are,
on that.
yes,
I'm not on that.
no, it cannot be done.
No, not in your case. Say in a given situation, I say my Mr. Rajesh, he is absent for 7 days.
Yes,
Can I first say that Diasnon and then say whether that period is unauthorized or not?
preceded by an inquiry.
Inquiry.
It cannot be, my lord.
So if I hold an inquiry first, come to the conclusion that this is unauthorized,
Yes,
then that period I can declare as
but yes,
Diasnon.
yes, ma'am.
You can't put the horse before the cart.
I
Yes.
got the,
You got the point?
yes, madam.
See that.
Yes, madam.
Tomorrow, 2 o'clock.
Fine,
But tomorrow close it.
Yes, madam.
yes.